Mention one application for inclusion in the list. It's an application payment for payment of one-time expenditure filed by the retired company paid staffs.
Company matter.
Company matter, in connection with a company matter in liquidation, that is not there, but my application is not is there. That application has to be disposed of, my lord.
The application is pending.
Yes.
Which for the other side?
But my lord Justice Smita Das Day was on behalf of the official liquidator before her elevation. Now I have sub notice, my lord, get the matter be listed, my lord.
You do one thing, come tomorrow at 2 p.m. Company matter will be taken, then you mention, I will take that.
Lord,
May I have your
Tomorrow
lordship?
at 2 p.m. you come.
Lord,
May I have your lordship's leave to mention?
May I have my lord's kind leave to mention a matter listed at 2 p.m. today? I mentioned it last Friday. Lordship had indicated that the matter come and then Lordship would adjourn. I had indicated that the witness has offered a bereavement in his time. And I'm mentioning upon notice to my other side, mother. It was fixed for witness action. We were supposed to start witness action.
Who's for the other side?
Friend is appearing for the case.
Okay, come at 2, I will.
My lord, may I have your lordship's kind leave to mention upon notice?
Yes.
This is my suit, my lord. Pursuant to the order passed on 20th of May 2025, a leave was granted to the plaintiff to disclose additional documents and for re-examination of the plaintiff's witness. So just for the fixing of date, so far as the re-examination is concerned, I was
Which for the other
beseeching
side?
my learned friend is,
for defendant number 4.
my lord. This is the notice of mentioning, and this was the order which was passed on 20th May. If your lordship kindly turns to the last page, 15, Roman 2 of continuing paragraph 18.
Inspection completed?
No, we offered them inspection within the time. They did not take inspection. That is why it should be deemed as closed. Otherwise, they are aware of all the documents because those were forming part of my application by which I wanted to disclose the additional documents.
Yes. So after the inspection, now recalling.
Yes, my
Examination of the witness on recall.
yes,
So I will fix the date for the witness action.
yes, your lordship.
Yes.
I don't think she has any objection.
No, my
So you will not inspect the document. Your time is over.
The time period has
No,
expired.
I am telling if I fix the witness action, then you cannot
will
say on
continue,
that day,
yes.
then I have to go to the, I have to inspect the document. You will not inspect.
No, my lord.
But they were actually aware of the documents. These are all issued by RBI and my lord, I'm led by Senior Mr. Ghosh in the matter. If this matter could be kept anytime post 17th of August, your lordship.
I don't think any time before September, August. August is also not having any.
Oh.
When is the first date you will get? 15th of September.
Okay, 15th of September, 2 p.m.
2 p.m.
Grateful.
The matter is mentioned by the learned counsel appearing for the plaintiff after notice to the learned counsel for the defendant. Counsel for the plaintiff submit that in compliance of the order passed by the coordinate bench of this court, dated 20th May 2025, the plaintiff has offered the documents for inspection to the defendant, but the defendant has not come forward for inspection of the document, additional document of the plaintiff. So counsel for the defendant, they will not inspect the document, and police in view of the above, let the matter appear on 15 September at 2 p.m. for examination of the plaintiff witness number 1.
Yes,
Only
PW1, only witness.
Plaintiff witness number 1 on recall for further examination.
Grateful to
May I have your lordship's kind leave to mention a commercial suit, your lordship. Your lordship had issued the subpoena for examination of the defendant witness number 3. The defendant, your lordship. And pursuant to your lordship, to the application which your lordship had heard, my lord, a subpoena was issued on 3rd July. Wherein in the subpoena it was written that the special witness, who is the director of CFSL Bhopal, was to be present on 28, if required, then 29.
Hmm.
My lord, on both the dates he is present.
Today is 29th.
Today is 29th, your lordship, and his return ticket is
Booked today.
booked today.
Hmm.
May I make my prayer first before my learned friend?
So what
reject?
you are?
My lord,
I wanted to mention, Your Lordship, I am entering upon notice.
Ah.
I need an indulgence from Your Lordship that it be extended by 1 day. I have communicated because the
Official.
court officers cannot stay beyond 6:30. That is the only problem.
No.
I cannot continue beyond
was
that.
never told to
Your
us,
Lordship can direct that, direct it
It was
to
Well,
go
the
on.
court, that's why I fixed them. Officer cannot be written like this day to day. Officer
It is-
cannot.
it is
If you
happening
completed,
today, Your Lordship.
completed,
Kindly-
not completed, not
Lordship,
completed.
kindly
I will direct the commissioner to record it as a close.
No, Lordship, I am doing it.
So why you are not completed?
It is, Lordship, it is doing on a day-to-day basis. Lordship is
What
aware-
when it was started yesterday?
yesterday.
What when what time?
5:30
4:30 we will start the house.
5 o'clock, the commission again, they
Sorry,
conducted the examination in chief, Your Lordship.
Whatever
Kindly
it
appreciates
for
they
10 minutes
conducted the examination in
this
chief.
court has already given is the official witness. And also is the director of the CFSL in a
Kindly
main
appreciates-
post. The court
kindly-
cannot retain the witness.
I bow down to your Lordship. What your
Whatever
Lordship
it may be, you complete today. You
Kindly
complete.
appreciates the fact that when the witness is being cross-examined, he
Yes.
is the director, he is a special witness, he is the expert.
Yes.
Lordship, they have conducted the chief, examiner in chief. I have the deposition, soft copy of the deposition.
When
which
the chief was completed.
it
Well,
was that
yesterday.
day only.
Yesterday
And
within
we
10
started
minutes,
cross-examination.
within
No,
10
no,
minutes.
it is not. I have the deposition and soft copy. I can
You are
hand
not
over
started cross-examining yesterday.
immediately, Lordship. It will not.
Complete it.
Lordship, you kindly
For
appreciate
the
it.
for the
Lordship is aware-
extent, how much time you
Your Lordship
require?
is aware when a witness,
Documents.
may I, Your Lordship? Your Lordship is aware when a witness is asked questions, the witness will give answers to certain things which will lead to asking the
Sir,
witness more
he is
questions.
the witness director. He
Yes, Your
cannot
Lordship.
stay here, but he has to get an approval from the competent
No, I am
authority,
taking the
Ministry of
liberty-
Home,
I am-
Ministry of
I
Home
will
Affairs. He is under the Ministry of Home Affairs,
Yes, Your Lordship.
not
that
under
is-
the
that
state
is-
government.
That is exactly why I am beseeching Your Lordship to grant.
And you know,
one
with
day
regard to the
extension.
CFSL, there is a girth of officers in the CFSL
Kindly-
nowadays.
I appreciate what Your Lordship is saying. Kindly directs, kindly gives me the time to at least finish it till tonight. If required, it can go on till 8 o'clock. That's
What
all
time
I'm
the flight is there?
My lord, at 9 p.m. the flight is booked, Your Lordship. This flight
And
is booked.
no, you start. Who is the commissioner? You start. Go at after lunch and you start that. No problem. 9 p.m. He has to leave by 7.
Lordship appreciates that the court
When
officer has
the
to come.
witnesses.
The court officer.
I will send the court officer, no problem. I will send my one of the court officers.
Lordship,
There, no problem.
Lordship does that. I have no problem. I
You
cannot
start
stand
at 2 p.m. No problem. You tell the commissioner to hold the commission from 2
I'm
p.m.
grateful. And I'll
Grateful.
I'll immediately.
I bow down to Your Lordship.
May I have your lordship's leave to mention this contempt application? There has been a contempt of your lordship's order dated 6th March 2025. Lordship had directed the respondents to take down the articles from their websites. The same has not been done yet. This contempt application is not appearing in your lordship's list. Would it please your lordships to take up this contempt application?
Contempt in the commercial matter.
Commercial matter, lordship.
What? You have not moved the contempt application.
Lordship?
You have not moved the contempt application
No,
earlier.
Lordship, it has not been.
When
moved
you
yet.
filed.
It was filed on 8th July.
So it will come. What is the returnable date?
Lordship,
What returnable date you have given in the presentation form?
Lordship, returnable date, Lordship, the thing is that there is one urgency. They have not taken down the articles from the website, Lordship, and this is causing
Okay,
harm to
then
my
will be
business.
if you are given the returnable date, how it can be taken out of turn? See when is the when the returnable date is mentioned in the presentation form.
Lordship, that has elapsed, if I am not wrong, and still it's not appearing in the list. This is what my instructions are.
Okay, Kalra.
Lordship, grateful.
Yes.
May I have your lordship's kind leave to mention a matter, my lord? Yesterday, your lordship pronounced the decree, my lord, in that other matter. My lord, only thing, my lord, Mr. Mukherjee's junior, my lord, who had worked also very hard, my lord, his name has been
Why the name is not so? Why ये क्यों हो रहा है ये? मनुतोष क्यों हो रहा है? नाम क्यों नहीं आ रहा है? हाँ तो फिर नहीं, he was there.
My lord, I've just indicated that, my lord, if this could be, my lord, just incorporated and re-uploaded, my lord. That's the only thing, my lord.
Grateful and deeply obliged.
Grateful to your lordships.
Yeah, my lord.
The matter is mentioned by the learned advocate appearing for the plaintiff
Upon notice, my lord.
upon notice
Notice.
to the learned counsel for the defendant. Number 1. Counsel for the plaintiff submit that in the judgment dated 28th of July 2025, in the cause title, the name of one of the advocate, the surname of one of the advocate, namely Soumya Roy Chaudhary, has been inadvertently recorded as Soumya ROY. पहले आगा RAY होगा, ये होगा ROY Chaudhary, and he prays that the name is to be corrected as Soumya RAY Rai Chaudhary. He further submit that for the plaintiff, another advocate had also appeared along with the senior advocate, another advocate, Mr. Naman Chaudhary.
Yes, my lord.
Mr. Naman Chaudhary has also appeared along with the senior advocate, Mr. S.N. Mukherjee, but his name is not recorded. In view of the above, in the order date, in the judgment dated 28 July 2025, in the cause title, the name of the advocate Soumya Roy Chaudhary shall be read as Soumya R.A.Y. Ray Chaudhary, and name of Mr. Naman Chaudhary be recorded as one of the advocate along with S.N. Mukherjee, senior advocate for the plaintiff.
But if this is re-uploaded, my
This order may be incorporated with the order dated 28 July 2020.
May
It-
my lord kindly to mention, my lord, for inclusion, especially assigned matter, my lord, the assignment list is there, my lord.
Why especially so many specialists and why it has
The fourth item from bottom, my lord. It's a specially assigned matter, my lord, fourth item from the bottom, my lord.
come here?
My lord, the assignment is, my lord, the fourth item from the bottom. I'm grateful.
I appear for the plate.
The defendant is directed to pay an amount of 1,38,94,743 along with interest at the rate of 18% per annum from 1st April 2021 till the realization of the said amount. The defendant is also directed to pay the cost of rupees 1 lakh to the plaintiff.
Grateful, ma'am.
If it is disposed of, decree it on accordingly.
Item number 2, I appear for the defendant. Yesterday, your lordship asked me to take a date from the defendant so that the cross-examination may be fixed by the
Huh?
lordship. Yesterday, your lordship asked me to ask my client about a date. My lord, when your lordship will fix the cross-examination before the commissioner. Now, my lord, 8th August and 11th August he is available. I have talked to the commissioner, my lord. 8th August he was ready. My lord, if 8th August we
Only
fix,
cross-examination is required
only
Yes,
one
ma'am.
date
of
is
the
required.
defendant.
Only
Yes,
one
ma'am.
date.
Who is commissioner?
Well, Mr.
Mr. Prabhakar Chaudhary.
So when when your witness will be available?
8th August, my lord.
8th August. On the one day it will be completed.
Only one day was left, my lord. That day we took an adjournment because the flight rescheduled.
You will cross-examine.
No, my lord, my learned friend will cross.
One day you will complete.
Yes, ma'am.
Though the matter was fixed yesterday for filing report by the commissioner, but the learned counsel for the defendant has taken time to ascertain when the defendant witness will be present before the commissioner for further cross-examination. Further cross-examination?
Yes.
Further cross. Today, when the matter is taken up for hearing, common learned counsel for the defendant submit that the witness of the defendant will be available on 8th
8th August.
August 2025. And he will complete this
Yes.
full story. 8th August 2020. In view of the above, time to file report by the commissioner is extended till 19th August 2025. List the matter on 19th August for filing report by the commissioner.
Grateful to you.
I appear for the plaintiff, my lord. That this matter was mentioned yesterday, my lord, that despite service, my lord, the defendants have not yet, my lord, even entered appearance. So I was humbly praying if your lordship will kindly, my lord, set the suit as undefended. Yes, my lord. I'm sorry, my lord, I'll hand over the originals.
Okay. Keep it with the
Lordship will
Seventh
see, my lord, in
February.
the, yes, my lord. Both mode of services in one of the addresses served. The first, and my lord, this is my lord, the report that at least on till 24th of June they have not entered.
Record. Counsel for the plaintiff has handed over the service report dated 17 June 2025, wherein it reveals that the writ of summons was served upon the defendant on 7th of February 2025 at the first address mentioned in the
The
first
fifth also, my lord, at the first, my lord,
first address at the
first call, first, my lord, row, the first box, my
Hmm.
lord, it is dated. This was, my lord, personal service
personal service also
on 5th of February,
okay.
and then
Okay,
postal
well,
service 7th of February.
it reveals that the writ of summons through the bailiff was served on 5th of February 2025 and through the postal services on 7th of February 2025. So the plaintiff has also obtained a report from the deputy registrar within bracket CT and J dated 29th June 2025, wherein it reveals that defendant has not entered appearance either in person or through an advocate till 24th of June 2020. Let the report be kept with the let the copy of the report be kept with the record. As the defendant, in spite of receipt of the writ of summons, has not entered appearance accordingly, CS Com 835/2024 be placed in the list of undefended suit. The plaintiff is directed to file the judge's brief of document.
In that regard, may I only submit this, my lord? We may, my lord, proceed to, my lord, depending on the merits of the matter. The lordship will keep it, my lord, as ex parte. My lord, we will take appropriate steps. My lord, if required, we will mention the matter.
Defendant suit. List the matter on 21st of August.
Deeply.
Yes, next.
My lord, in this matter, I appear for the plaintiff, my lord. The plaint was admitted on 12th June. My lord, upon scrutiny by the department, there is some typographical error.
7 defects are there.
7 defects are
How much
there, my
time you
lord.
will take?
My lord, 2 weeks will be sufficient to clear the defects. And my lord, one more prayer, a liberty may be given for reaffirmation and re-verify the affidavit.
Matter is listed as to be mentioned on receipt of the report from the office of the London Master. It is fine from the report that on scrutiny of the plaint, the department has found altogether 7 defects. Counsel for the plaintiff prays for 2 weeks time to cure the defects as pointed out by the department. The counsel for the plaintiff also prayed for leave to re-verify and reaffirmation of the affidavit.
My lord, one more prayer, my lord. As the master summon need to be issued, as the writ of summon need to be issued within 14 days. That 14 days has already elapsed.
That after completion that.
My lord,
In view of the above, the plaintiff is directed to complete the cure the defects within 2 weeks and also given liberty to file to re-verify and reaffirm the affidavit within a week thereafter. Full stop. Immediately after rectification, complete rectification of the defects, the plaintiff is directed to take appropriate step for issuance of writ of summons. Next.
much obliged.
Yes.
There seems to some defect.
Four defects.
Well, I was told there were 2 defects, my lord.
4 defects. Statement of truth. One is 1 ABC, then second correction required in paragraph 6, correction required in paragraph 3. Cost title has not been verified and verification.
Well, verification, I was told that there has to be some paragraphs which has to be submissions.
Submission. You have not mentioned that.
Well, my contention, I'll not. Well, my contention is in a plaint, well, there need not be any submissions. Well, all are facts.
All new things are
do
coming
the
from the
necessary,
department. Counsel for the matter is listed as to be mentioned on receipt of the report from the officer from the office of the London Master, and it is found that at the time of scrutiny of the plaint, altogether 4 defects have been found. Counsel for the plaintiff prays for 2 weeks, 1 week.
2 weeks.
Prays for 2 weeks time to rectify the defects and also prays for leave to re-verify and reaffirmation of the affidavit of the plaint. In view of the above, the plaintiff is directed to rectify the defects within 2 weeks and to re-verify and reaffirm the affidavit of the plaintiff within a week thereafter. Immediately thereafter, the plaintiff is directed to take appropriate steps for issuance of writ of summons. Next.
My lord, I'm led by senior Mr. Shah in this matter. He was in the course of addressing your lordship in reply.
Yes.
My lord, he's addressing court number 26, my lord, the division bench. With your lordship's leave, my lord, I can start. He should be on his way. My lord, after we advanced our submissions, my lord, the respondents have taken a point of maintainability, and thereafter they have also proceeded to address your lordship on the merits of the matter.
Correct.
So, my lord, the maintainability, they're assailing, my lord, on the ground that these are issues which the NCLT is competent to decide. My lord, they have relied on sections 63, my lord, 231 and 238 of the Insolvency and Bankruptcy Code.
Yes.
Now, my lord, if your lordship will kindly have the code once, my lord.
Yes.
Section 63, if your lordship will kindly see, my lord. 63, my lord. These are the provisions that were relied upon by the respondents.
Yes.
My lord, 63 says, no civil court or civil court not to have jurisdiction. No civil court or authority shall have jurisdiction to entertain any suit or proceedings in respect of any matter on which the National Company Law Tribunal or the National Company Law Appellate Tribunal has jurisdiction under this code. And section 231, if your lordship will kindly turn to, my lord. So the salient, my lord, phrase is issues that the NCLT is competent to decide, my lord. Civil court will not be able to assume jurisdiction.
Yes.
231 says, my lord, bar of jurisdiction.
Yes.
No civil court shall have jurisdiction in respect of any matter which the adjudicating authority or board is empowered by or under this code to pass any order, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any order passed by such adjudicating authority or board under this code. So, my lord, the issue that falls for your lordship's kind consideration is whether the NCLT is either empowered to or has the jurisdiction to determine whether the loan whether there has been a breach of the loan agreement, my lord. That is essentially the issue that is calling for your lordship's kind consideration in this matter. My lord will see here, my lord, there are successive loan recall notices.
Yes.
There are two loan agreements, my lord, just to refresh your memory on lordship's memory on the facts, my lord.
Yes.
There was one loan agreement of 2018,
yes,
where the petitioner number 1, represented by Mr. Mukherjee, my lord, was the borrower.
Yes.
My lord, we complained that there were usurious rates of interest being levied.
Yes.
My lord, which was dehorsed the contract between the parties, and also, my lord, the guidelines framed for, my lord, carriage of business by NBFCs. And, my lord, it is in these circumstances that the respondents, my lord, prevailed upon us to take a fresh loan in the name of the petitioner number 2 in 2022. The sums disbursed under that loan would be used to repay the facilities under loan 1 in 2018, extended to the petitioner number 1.
Correct.
Thereafter, my lord, we have been paying regularly, but lordship has been told that in the past also, my lord, in the course of adhering to our repayment obligations under loan 2, there have been instances of delayed payment. This is very material, my lord, because how the parties understand the contract is demonstrated by their conduct. So in the past also, there have been instances of delayed payment that has not, however, triggered any kind of breach or default. The respondent has not, my lord, treated that as a condition precedent or, my lord, a term of essence of the contract. They have not either sought to, my lord, repudiate the contract or, my lord, terminate the contract and recall the entire loan or even a part of the loan on account of delay in repayment in past instances. Because, my lord, the loan agreement categorically provides that delay in payment can be adequately compensated by the levy of default interest or penal interest. The phrase, my lord, in the clause says that it is considered to be a genuine pre-estimate of the loss and damage caused to the bank as a consequence of the delayed repayment. Now, what has happened, my lord, is in each instance when there is delay in repayment, my lord, the bank has levied and realized this default interest. In the aforesaid manner, my lord, any delay has been cured, any breach of the time stipulation in the loan agreement for payment of the installments is cured, and they have treated it to be so, and the parties have gone about with the performance of their contractual obligations. We have been repaying. Now, my lord, installment fell due in April 2025. There is admittedly a delay in repayment of that. That is, my lord, treated to be a breach of a fundamental condition which would entitle the bank to repudiate the contract. And thereafter, my lord, I will show your lordship has seen it. I'd like to place that clause again, my lord. Clause entitles the respondent in the event of delay in repayment to either, my lord, recall a part or the entirety of the outstanding under the facility. They have, my lord, exercised this option. They have elected to recall only part. And, my lord,
Recall only part means?
Recall only part of the loan, the part falling due in, my lord, April 2025. My lord will see under section 59 of the Contract Act also. I'll take your lordship through the provisions, my lord. I'm just trying to give your lordship the general scheme of my argument that I want to advance before your lordship. That, my lord, each installment that falls due is a separate component of the debt. My lord, the contract entitles the respondent to recall either a part or the whole. My lord, the doctrine of election says that when there is an option and you have exercised this option and you have, my lord, induced the other party to act to his detriment on the basis of this election, you are stopped from, my lord, resiling from the election that you have made. Now, let me just try to contextualize my submissions, my lord, by showing your lordship the relevant provisions of the contract once more.
Where is the recall?
My lord, there are successive recall notices. Your lordship will find the first one at page 587, volume 4 of the petition. That is 28th May 2025. Before that, my lord, may I just show your lordship the relevant provisions of the contract once again? That will perhaps, my lord, lend some context. If your lordship will kindly have, my lord, clause 17.1.2 of the 2022 loan agreement, lordship will find that at page 174 of the petition.
174?
Yes, my lord. Volume 2. Yes. My lord, if your lordship will have the loan agreement and the recall notice side by side, perhaps it will help your lordship, my lord. The recall notice I showed your lordship is at page, my lord, 587 at volume 4. And, my lord, the loan agreement is in the second volume.
Yes.
Does your lordship have, my lord, clause 17.1.2 at page 174?
Yes.
If your lordship will kindly allow me to place this, my lord. It says, or may I place from clause 17 at the previous page, my lord, from 173.
Yes.
It says 17.1, on occurrence of an event of default, the lender may, in the event, have the right described hereunder and the rights available under applicable law as well as under any security document created in accordance with these terms and conditions. 17.1.1, cancel or terminate any available commitment. 17.1.2, declare that all or part of the loan, together with accrued interest and all other amounts accrued or outstanding under the finance document, be immediately due and payable, whereupon they shall become immediately due and payable. 17.1.3, accelerate the repayment of the loan. So, my lord, this is what I was talking about. This is an option that, my lord, the contract entitles the respondent to. The respondent has to make an election that on the occurrence of a breach, will they elect to recall only a part of the outstanding, which is, my lord, the specific installment that falls due and which has been delayed, a payment for which has been delayed, or, my lord, whether they will proceed to recall the entirety of the facility.
Yes.
Now, my lord, on this aspect, if your lordship will permit me, my lord, one judgment is very relevant, my lord. If I may, with your lordship's leave, place it. Oh, election waiver judge. First one, because it is-
So you come to the page 587.
Yes, my lord.
That is the recall note.
That is the recall notice.
Yes.
So, my lord, here, if your lordship will see, 28th May 2025, subject is, my lord, repayment of amount due under loan agreement dated 30th June 2022, entered into by and between the lender and borrower and obligers defined hereunder. The loan agreement dated 30th June 2022, entered into by and between Piramal Capital, Housing Finance Limited and Money Realty Private Limited. And then the guarantors are listed, my lord. All documents, etc. Then your lordship will kindly see. We refer to the finance documents and notices mentioned above, and in respect thereto, relying on the representations of the borrowers and obligers and the security created, such and such, lender agreed.
Then it is under 16. Come to the page 176, clause
Yes.
16.
My lord will kindly come to 589, my lord.
589.
589, lordship will
Principal 12.75.
yes. Paragraph 5 also, we hereby recall, hereby call upon you to repay the total outstanding amount
Correct.
on 15 crore 40 lakh 96,746 within a period of 15 days from receipt of this notice.
Correct.
So, my lord, this is only the facility or the repayment of the installment that is falling due in April 2025, which is delayed. They have not proceeded to accelerate the entire loan or, my lord, allege that the entire amount is recalled. Now, my lord, why I say this amounts to an election under 17.1.2 of the 2022 loan agreement. But, and having elected, my lord, they are now stopped from going back and alleging that the entire facility stands recalled and the entire loan amount becomes due merely because you have delayed in payment of the April installment. Now, my lord, if your lordship will see the successive notices that your lordship will find at 591,
Yes.
8 June 2025.
Yes.
Kindly see, my lord, the tabulation of dues.
Yes.
Here they purport to contain, my lord, that the entire facility becomes outstanding. Same, my lord, again at page 595, that is of 13 June 2025. Here also, my lord, at 596.2, your lordship will see, in view of the recall of the loan, the total amount of rupees 92 crore 83 lakh 54,040 became due and payable by you as of 11 June 2025. So, my lord, this is really having elected, my lord, the remedy of, my lord, recalling only a part of the loan, because it is the case of the respondent that if there is a breach or if there is a default, it is only with regard to the installment that fell due in April 2025. And they have elected to, my lord, recall only that component. Whether they can now, my lord, proceed to say that the entire amount becomes outstanding.
Yes.
Now, my lord, the justification that the respondent has offered to say that no, they are entitled to recall the entire facility and claim the entire amount as outstanding in one go.
Correct.
Is, my lord, if your lordship will kindly turn to 587 again, that is the first recall notice of 28th May.
587, your time was given 15 days.
That's right. Now, this is very salient. At 589, my lord, paragraph 5, they say that you have to pay this amount of 15 crore 40 lakh 96,746 within 15 days from receipt of this notice.
Correct.
This 15-day period, my lord, does not find mention anywhere in the contract. This 15 days within which they are demanding repayment, this is not provided anywhere in the contract. The contract does not say, my lord, 17.1.2 of the contract I have shown your lordship, that nowhere says that in the bank makes an election to claim only, my lord, the delayed installment to be due. Thereafter, the bank can...
Okay, they have asked for the 15 days time.
Yes.
You have not paid.
No.
Then subsequent notice.
I have paid, my lord, not beyond 15 days.
Beyond 15 days, whatever
right.
it is, that date is not matching
That's
with
right.
regard to this
That's
notice.
right.
Now, thereafter, again, they have issued the notice.
Yes, my lord.
Then that notice under section, under clause 16. Total, kindly come to the 16.
Yes, my lord.
So they have recalled the total because you are not paid the total amount what they have claimed.
Yes, my lord. Here, if your lordship will kindly allow me, my lord. The Indian Contract Act section 55 was placed by us, my lord, when we advanced our argument. Section 55 has 3 limbs, my lord. It contemplates, my lord, what are the obligations of the parties when time contemplated for performance is of essence, and what are the obligations when time is not of the essence. If your lordship will kindly take section 55 once again, my lord, of the Contract Act. I come to that. Now, my lord, my contention, our contention has been that time, as time for repayment of the installment, my lord, under this agreement is never of essence and cannot be of essence. Why, my lord? Because the agreement categorically provides that, my lord, in the event of delay and for the duration of continuation of the default, my lord, you will have to pay penal interest or default interest.
Yes, that Mr.
And that will,
Asaj already
that's right.
argued that.
So, my lord, time is not of the essence. If time is not of the essence, then what is the consequence? Kindly see section 55, my lord. 55 says effect of failure to perform at a fixed time in contract in which time is essential. When a party to a contract promises to do a certain thing at or before a specified time, or certain things at or before specified times, and fails to do any such thing at or before the specified time, the contract or so much of it as has not been performed becomes voidable at the option of the promisee if the intention of the parties was that time should be of the essence. So, my lord, if time was of the essence and I have delayed in repayment, then, my lord, they would be entitled to repudiate the contract. However, my lord, kindly see the third limb. Effect of, so next portion, my lord, effect of such failure when time is not essential. If it was not the intention of the parties, the time should be of the essence of the contract does not become voidable by the failure to do such thing at or before the specified time, but the promisee is entitled to compensation from the promisor for any loss occasioned to him by such failure. So, my lord, if time is not of the essence, then, my lord, the remedy is only in course of damages.
Yes.
It does not entitle repudiation of the contract because it's not a fundamental term or an essential condition. If your lordship will kindly next see the next prong. Effect of acceptance of performance at time other than agreed upon. If in case of a contract voidable on account of the promisor's failure to perform his promise at the time agreed, the promisee accepts performance of such promise at any time other than that agreed, the promisee cannot claim compensation for any loss or occasion by non-performance of the promise at the time agreed unless at the time of such acceptance he gives notice to the promisor of his intention to do so. So, my lord, if you are accepting beyond time, you must reserve your right to claim compensation, otherwise you waive that also. Now, my lord, here, I have shown your lordship in the past also, my lord, there have been certain delays in repayment. They have never treated that to be of essence and purported to repudiate. Now, my lord, the clauses clearly contemplate, my lord, that if there is a delay, that is adequately compensated by payment of default interest payable as long as the default or the breach continues. If your lordship will kindly allow me to place that. And, my lord, this is also relevant. There are judgments, numerous judgments, my lord, by the Supreme Court, which has held that when there is a provision for, say, my lord, extension of time in a contract, or there is a provision for liquidated damages in case of delay, even though there is a clause in the contract saying time is to be of essence, you must read the contract holistically. And, my lord, on a harmonious construction of all the clauses in the contract, it will usually appear that time is in fact not of the essence, even though stipulated to be, because you have provided a remedy under the contract itself that in the event of delay, you are adequately compensated by payment of interest. Now, my lord, here, A, the bank has made an election to recall only a part of the facility. Yes. On the basis of that election, my lord, they have called upon me to cure the breach by payment. Now, my lord, there are judgments also to, and they say that this payment has to be made within 15 days. Now, my lord, this 15 days assumes significance. The contract nowhere says that if you don't pay the installment that falls due within 15 days of it falling due, the entire facility will be recalled. That is not a provision of the contract. And, my lord, in the course of construction, my lord, a term cannot be added to the contract. The contract has to be read in black and white, my lord, unless that would lead to absurdity.
Yes.
Now, my lord, if your lordship will allow me, my lord, I'm equipped with a decision also which says that, my lord, if there is a provision for interest, time is not of essence.
Yes.
That is important, my lord. That is, my lord, 2022 2 SCC 382, my lord, if your lordship will permit me, my lord. That is important. And one more proposition I would like to rely on is, my lord, if time is not of essence, you cannot repudiate, but then what is the consequence? Can you perform at any time of your choosing? That is not the law. I'll come to that next, my lord. 2022-2 SCC 382. If your lordship will kindly permit me, my lord. Paragraphs 33 to 36, my lord, delve into the issue of whether or not time is of essence and what are the considerations material in determining whether time is of essence. My lord, may I invite your lordship's kind attention straight to paragraph 42.1, my lord, at the second last page of the report, 397. Here, my lord, the court finds at 42.1.
Yes.
The arbitral tribunal's interpretation of the contractual clauses having extension procedure and imposition of liquidated damages are good indicators that time was not of the essence of the contract. So this is, my lord, well settled proposition of law. Even if you say time is of essence, but there are other provisions remedying, my lord, any damages or loss suffered by you as a consequence of the delay, then, my lord, it means that time is in fact not of essence, and that is the contemplation between the parties. My lord, one more decision, if your lordship will kindly allow me. This is very important. In 1999. This says, my lord, if time is not of the essence, then within how much time are you required to perform? This is, my lord, AIR 1999, Supreme Court 3209. Your lordship will kindly, my lord, have from paragraph 21 to 33. Again, my lord, the salient observation is at 32 that I would like to rely on.
Yes.
Kindly allow me one moment, please. Kindly allow me one moment while I was looking at Manupatra, the paragraphs may not match. Will your lordship kindly allow me to replace the report with a Manupatra copy, because that is the one I am also. Your lordship does not mind. Your lordship will kindly take, my lord, paragraph 32, and this is at, my lord, page 10 of the report.
Yes.
Having noticed the Constitution Bench decision in Chandrani, the Supreme Court has further held that even where time is not of the essence of the contract, the plaintiff must perform his part of the contract within a reasonable time. And reasonable time should be determined by looking at all the surrounding circumstances, including the express terms of the contract and the nature of the property. So, my lord, if the contract does not provide that time is of the essence, if from, my lord, a comprehensive reading of the contract, it appears that time is in fact not of the essence because it provides for any cure by way of payment of default interest, my lord, then the question is, within how much time do I have to perform? I have to perform within a reasonable time. If, my lord, I delay unreasonably, if, my lord, several months go by and despite repeated reminders, I am unable to pay, in that case, perhaps the bank will have be entitled, my lord, to recall the facility.
Yes.
But merely because I have not paid within 15 days as they have demanded, my lord, when this 15 days does not find any mention in the contract, it does not entitle the bank to recall the entire facility after they have made an election to recall only that installment which, my lord, was delayed. This is my humble submission. Now, my lord, if your lordship will kindly come to the agreement once again, my lord, there are two. Let me just show your lordship, my lord, the provisions for payment of interest again. This is very important. My lord, clause 2.3.1 of the contract at page 73 of the petition provides for payment of default interest. If your lordship will kindly have that. 3.1, my lord, page
Correct.
73.
159 is also there. Default interest.
Yes.
159 default interest.
Yes. if the borrower defaults payment of the outstanding amount on its due date, interest shall accrue on the unpaid sum from the due date up to the date of actual payment at the rate as specified in Schedule 2 hereunder. The default interest accruing under clause 2.3.1 shall be immediately payable by the borrower on demand by the lender. Default interest, if unpaid, arising on an unpaid sum, will be compounded with the unpaid sum at the end of each interest period applicable to that unpaid sum, but will remain immediately due and payable. The borrower hereby expressly acknowledges that the further rates of interest in this clause 2 are reasonable and they represent the genuine pre-estimate of the losses expected to be incurred by the lender in the event of non-payment of monies by the borrower. So it clearly contemplates, my lord, any loss occasioned to the lender as a consequence of the breach is remedied in this fashion. Then, my lord, your lordship will... That's it. Then, my lord, 17.1.10 is very relevant. That is at page 174. Your lordship will kindly see 17.1.10.
Yes.
This says, my lord, in addition to the above, so long as the event of default continues, the borrower shall pay default interest on the defaulted amount from the date of occurrence of the event of default here and above until such event of default is or are rectified, and final payment in respect thereof is made to the lender without prejudice to the remedies available to the lender or the consequence of event of default. So this says, my lord, this does not say that I have to repay within 15 days or otherwise, my lord, the entire facility is recalled. It on the contrary says that as long as the default continues, I will have to pay default interest or penal interest. So, my lord, here there is admittedly a delay in repayment.
But there is a provision also, second part, without any prejudice to the remedies available to the lenders or consequence of the event of default.
That's right, my lord. The consequences will have to be governed by the terms of this contract.
What Mr. Sakar has argued,
Yes,
you
my lord.
have given the first chance, you have not deposited subsequently, even there was delay.
Yes.
And then they have issued the notice and recalling that.
Yes.
And it is without prejudice. And as per the section 17.1.
Correct, my lord, it is. It is. My lord, the reason why I showed your lordship the last judgment, it says that if time is not of the essence, if, my lord, any loss to be occasioned to the lender as a consequence of delayed payment is compensated by penal interest, then, my lord, within how much time can I take a year to pay? That would be an absurd result. Now, naturally, the contractor cannot provide for that. So I have to pay within a reasonable time. Now, the question, my lord, that will beg your lordship's kind consideration is whether this imposition of 15 days is a reasonable time. If instead of 15 days, I pay on 17 days or 18 days, is it so unreasonable as to entitle the lender to recall the entire facility? That is the question that will have to receive your lordship's kind consideration.
Okay.
And, my lord, these issues are matters of strict interpretation of contract. These cannot be done in a summary proceeding, my lord, before the NCLT. So that will also bring me to the case of, my lord, the maintainability issue that is urged by the respondents. But, my lord, for the time being, if your lordship will kindly consider, nowhere does it say that if within 15 days of the installment falling due I do not pay, entire facility will be recalled. That is dehors the contract. The installment fell due on 5th April, my lord.
Yes.
It has been repaid. Now, my lord, if I have not made payment within 15 days, whether they are entitled to recall the entire facility, whether I have made payment within a reasonable time, and as a consequence, they are not entitled to recall the remaining facility, specifically having made an election to recall only that one installment, my lord, which was delayed. These are the questions which will have to, my lord, receive your lordship's kind consideration. And kindly see, my lord, as long as, my lord, the default continues, subject to whatever other remedies they may have under the contract and in law. Under the contract, nowhere does it say that if, my lord, default continues for more than 15 days, they will recall the entire facility. These are important things. Now, my lord, in this context, my lord, since I have urged the point of election made by the respondent before your lordship, kindly allow me to rely on one other decision on this aspect. First, 2016. My lord, this is 2006, 8 Supreme Court cases, page 726, at paragraphs 73 to 75, my lord. Page 36 of the report. Kindly see, my lord. Paragraph 73, waiver. The matter may be considered from another angle if the first respondent has expressly waived his right on the trademark registered in the name of the appellant company. Could he claim the said right indirectly? The answer to the said question must be rendered in the negative. It is well settled that what cannot be done directly cannot be done indirectly. Then, my lord, waiver is delved into. What is the meaning of waiver and estoppel? The term waiver has been described in the following words. Waiver is the abandonment of a right in such a way that the other party is entitled to plead the abandonment by way of confession and avoidance if the right is thereafter asserted and is either express or implied from conduct. A person who is entitled to rely on a stipulation existing for his benefit alone in a contract or of a statutory provision may waive it and allow the contract or transaction to proceed as though the stipulation or provision did not exist. Waiver of this kind depends upon consent, and the fact that the other party has acted on it is sufficient consideration. It seems that in general, when one party has, by his words or conduct, made to the other a promise or assurance which was intended to affect the legal relationship between them and to be acted on accordingly, then once the other party has taken him at his word and acted on it so as to alter his position, the party who has given the promise or assurance cannot afterwards be allowed to revert to the previous legal relationship as if no such promise or assurance had been made
Where
by
is
him.
the promise that they will not revoke if you
Kindly allow me to read the next line, my lord. I will address your lordship's concern. To revert to the previous legal relationship as if no such promise or assurance had been made by him, but he must accept that legal relationship subject to the qualifications which he has himself so induced, even though it is not supported in point of law by any consideration. Next paragraph, my lord, 75. Waiver may sometimes resemble a form of election and sometimes be based on ordinary principles of estoppel. Now, my lord, my humble submission is that the bank respondent has elected to, my lord, recall only part of the facility that fell due in April 2025. And they have, my lord, called upon me to pay default interest. Kindly note one document, my lord. This is very important. Immediately after the loan fell due, my lord, in April 2025, they issue this letter to me. Page 563, my lord. This is, my lord, in the 4th volume. This is the first communication written to me after, my lord, the purported breach in payment of the installment falling due in April. 7th April 2025. Kindly see, my lord, at the next page, 564, paragraph 2. As per clause 4 of the loan agreement, the borrower is required to repay the amounts, principal and or interest due as per the repayment schedule mentioned in the loan agreement, mentioned in part 1 of the second schedule. Further, clause 2.3 of the loan agreement read with the second schedule therein further provides that any default in repayment of amounts due to the lender and under the loan agreement will be 24% per annum, and the interest period for such unpaid sum shall have a duration calculated from the due date till the date of actual payment. Then paragraph 5, my lord. In view thereof, we hereby call upon you to cure the default forthwith and make repayment of the balance net outstanding amount within 7 days of receipt of this notice, failing which the lender and or security trustee shall be constrained to exercise all rights available under the loan agreement and or other financial documents and under applicable law.
So where is the promise?
So-
They have not stated that if you pay, then
Kindly see, my lord. First, they say 7 days you have to pay.
correct.
Otherwise, consequences will follow.
Correct.
Then they say 15 days you have to pay, otherwise consequences will follow. The contract does not provide for either of these durations. These are self-imposed conditions, and the contract provides that any duration of delay will be cured by payment of default interest for as long as the default continues. That is relevant. Now, what has happened, my lord, is I have paid the default interest. They have appropriated it towards, my lord, the default interest for the installment that fell due in April, and, my lord, they have also appropriated payment for the subsequent month.
Yes.
So, my lord, having done that, they are stopped from claiming that the entire facility fell due, and the delay and the loss or damage caused to the respondent as a consequence of delay is not cured, because they have induced me to alter my position to the detriment by paying this default interest. They have accepted it and appropriated it towards these specific payments. My lord, with your lordship's leave, my lord, Senior Mr. Shah is leading me, my lord.
Lord, my apologies, my lord. Well, I shall try to answer your lordship's query, my lord, straight away. My lord, we are, my lord, now, my lord, talking to the contract. The contract, my lord, your lordship has seen, provides for, my lord, payment of, my lord, the dues within stipulated times in the installments specified, and also provides for payment of default interest. Now, clause 2.3, I've shown your lordship. Clause 2.3 has, my lord, two components. One is, my lord, that if you do not pay the installment within the stipulated date, then you shall pay default interest on that. And, my lord, very, very important is that even if you fail to pay the default interest, even that can be cured by paying compound interest thereon. Now, my lord, what is very important here is, my lord, therefore, we, my lord, come away with this clause from, my lord, time of essence of the contract provision. Time is no longer of essence. Now, if time is no longer of essence, then, my lord, within what time can the default be cured? That is, my lord, the question. Now, my lord, I would have appreciated the contract providing that your right to cure the default will cease on the expiration of 15 days or 20 days or 25 days or 30 days or 1 month or 2 months. There is no such provision. I would have also appreciated that, my lord, the contract, my lord, contains a provision that, my lord, after this, you will have no right to cure the default by paying penal interest otherwise. That is also not there. So, my lord, time is what we call, my lord, in the contractual terms, is at large. Now, my lord, will that, my lord, that mean indefinite? No, that is not the law. The law is when, my lord, the contract does not provide for a specified time period within which to perform an obligation, then it must be done within a reasonable period. Now, my lord, my learned friends, initially, my lord, your lordship has seen the letter of 7th April. That says you give it within 7 days. Then 28th May, they said give it within 15 days, 28th May, because I've started paying already. Now, my lord, these are, my lord, impositions that are, my lord, made by themselves on their own. This is not, my lord, following the contract. Now, my lord, the question is, my lord, what would then be a reasonable period? That is the question. My lord, I shall cite an authority to that effect. My lord, reasonable period is what, my lord, is reasonable in the context of the transaction that the parties have undertaken. We have already, my lord, shown to your lordship, my lord, from the pleadings that even in the previous instances when there had been default, we have cured the default, made payment of the installments along with the interest and default interest. Now, my lord, so far as this is concerned, your lordship remembers that, my lord, they had given the 28th May letter saying that pay it within 15 days. That takes us to the 13th of June. My lord, we paid the entire money along with default interest by 18th of June. The question is, my lord, whether then that period payment has been made within, my lord, reasonable time. My lord, kindly, my lord, in this regard, have a look at, my lord, one decision of the Supreme Court, 1999 to the. Oh, দেখেন reasonable period দেখেছো? হ্যাঁ, এটা দেখেছো? My lordship has seen. Well, I am sorry, my lord. So, my lord, therefore, the question is, my lord, whether, my lord, the default has been cured and whether it has been cured within a reasonable period. Second very important part. My lord, when they call upon me to pay, they call upon me to pay, my lord, along with the default interest. Now, my lord, when I say, when you call upon me to pay with the default interest, you are, my lord, saying that you are invoking that clause. When you're invoking that clause, then, my lord, you accept the fact that, my lord, today you are giving me an opportunity of paying default interest and curing the default.
Yes.
When I make the payment, this is very, very important, I specify that I'm not making the payment on an ad hoc or a lump sum basis. I say that I'm making the payment specifically on account of, my lord, the installment or the balance of the installment that fell due on the 5th of April, and, my lord, on account of interest and on account of default interest. My lord, that brings us within the realm of Section 59 of the Contract Act, appropriation of payments. When I say that I'm, my lord, making payment towards a particular, my lord, loan or a particular component of a particular loan, in that case, my lord, ultimately you have to accept it, my lord, in the terms of my offer only. My lord, may I just read out the language of Section 59 once? It says, where a debtor owing several distinct debts to one person makes a payment to him either with express intimation or under the circumstances implying that the payment is to be applied to the discharge of some particular debt, the payment, if accepted, must be applied accordingly. Now, my lord, when I make this payment towards discharge of the particular debt of the installment of 5th April, and, my lord, when I specify that I'm paying along with the default interest, then, my lord, I'm discharging that debt and it's totally. So, my lord, that debt does not subsist. If that debt does not subsist, the question is whether the rest of the loan can become payable. Now, my lord, so far as that is concerned, now, my lord, so far as the rest of the loan is payable is concerned, my lord, today, I could have again appreciated my learned friend saying that, look, since we have exercised our right to terminate the agreement, we will not accept any default interest from you because that would enable you to cure the default. There is no, my lord, attempt to, my lord, say that we are not going to appropriate this default interest towards discharge of the debt. On the contrary, my lord, if one follows sections.
They have taken the benefit of the cost, taking the interest as well as you are not.
Yes,
paid
but
the
my lord, here with the greatest of respect, my lord, today then they have to say, because my lord, their repeated entreaty is that pay it with the default interest. And my lord, now my lord, I filed a supplementary affidavit showing that I've even paid the entire installment for the month of July. Well, I have not prepared a supplementary. Well, July 2025, the next installment falls due. I have paid that entirety of the money along with default interest. Now, my lord, today, even that money they have accepted. My lord, we are talking about, my lord, two things. My lord, your lordship is not adjudicating the dispute finally. Your lordship is only trying to find out as to, my lord, whether we have made out a prima facie case. Now, my lord, prima facie case, my lord, is something that must follow the agreement. My lord, two essential legal principles, my lord, time not of essence. If time not of essence, I can cure it by paying damages. Damages stipulated, specified, accepted as genuine pre-estimate. Well, I've paid the damages. Now, they only say, their only case that they now run is that, look, you should have paid it within 15 days, but you paid it within 20 days or 18 days. Well, with the greatest respect, if the contract does not specify a time stipulation, then my lord, all that I'm required to do in terms of, my lord, the section 55, in terms of the Supreme Court judgments, is paid within a reasonable period. I've paid it within the reasonable period. Well, then, my lord, the question of default surviving does not arise.
Okay.
Well, if the default does not survive, if the default does not subsist, then, my lord, the question of ultimately putting me, my lord, to the consequences of the default, my lord, will be unjust, unfair, and divorce the contract. Now, my lord, so far as this is concerned, this is, my lord, the question of, my lord, default. This is on the contract. Now, my lord, the second question that my learned friend had raised was, my lord, the question of, my lord, after that, my lord, your lordship has seen, my lord, that, my lord, two questions that were raised were section 63 and 231. And, my lord, also the question of, my lord, the section 41B. Now, my lord, so far as that is concerned, my lord, here, my lord, your lordship will see that, my lord, so far as section 63 is concerned, well, your lordship has seen the language. It's very clear that, my lord, it is only on matters which the NCLT can adjudicate. Now, my lord, so far as this is concerned, I have already made my submissions that please see, my lord, a few judgments, 2021 to the. Will you please see paragraphs 69 and 74? Two paragraphs.
69, 74.
Yes, ma'am. I've given Indus. Oh, you've given Indus Biotics. Oh, my lord, I'm sorry, my lord. Indus Biotics. My lord, Indus Biotics, paragraph 34, 35. Well, these are the relevant, my lord, paragraphs in Indus Biotic. Well, in Indus Biotic, my lord, what had happened was, my lord, there was an attempt to invoke the arbitration clause. And, my lord, section 7 pending. My lord, the court said that, my lord, today, so far as the adjudication is concerned, it is only after the petition is admitted, it becomes an action in rem. My lord, may I just place these two paragraphs? It will become clear. My lord, this is on the aspect of default again. My lord, please see, my lord, first paragraph 33. In the letter dated 21st November 2018, addressed by Indus Biotech Limited to Kotak India Venture, it was mentioned with regard to the fundamental issue that needs to be addressed regarding conversion and convertible securities into equity shares, since the exit process initiated cannot move forward without such conversion. Letter dated 17th December 2018, addressed to Indus Biotech by Kotak India Venture, in fact, refers to the stake in conversion and the dispute offered, and the dispute being as to whether it should be 10% of the share capital of the company as offered by Indus Biotech Private Limited or 30% as claimed by Kotak. It is this aspect of the matter which is still contended to be in dispute between the parties regarding the arbitration, regarding which arbitration is sought by Indus Biotech, which was also noted by the adjudicating authority. We expressed no opinion on the merits of the rival country. Well, this was the dispute, 30% or 10%. Well, here the dispute is whether, my lord, it has been cured, default has been cured, or default continues to subsist. Then, my lord, in such situation, our opinion would be premature at this point to arrive at a conclusion that there was default in payment of any debt, until the said issue is resolved and the amount repayable by Indus Biotech Limited to Kotak India Ventures with reference to equity shares being issued is determined. In the process, if such determined amount is not paid, it will amount to default at the stage. Therefore, if the matter is viewed from any angle, not only the conclusion reached by the adjudicator authority NCLT insofar as the order on the petition under Section 7 of the IBC is concerned, at this juncture is based on the factual background is justified, but also prayer made by Indus Biotech for constitution of arbitral tribunal, because there was Section 8 application. In the circumstances, though in the operative portion of the order dated such and such, application filed under Section 8 of the 96 Act is allowed, and as a corollary, the petition under Section 7 of the IBC is dismissed. In the facts and circumstances of the present case, it can be construed in the reverse. Hence, since the conclusion by the adjudicating authority is that there is no default, the dismissal of the petition under Section 7 of IBC at this stage is justified. Although the application under Section 8 of the 96 Act is allowed, the same in any event will be just subject to the consideration of the petition filed under Section 11 of the Act of 1996. Well, what therefore essentially was in issue was, well, the matter was being considered by the NCLT. The issue was, my lord, whether today the obligation under the contract was 10%, 30%. The NCLT said that I can't decide this question. I can't decide as to whether, my lord, the contractual obligations have been duly performed or not duly performed. Now, my lord, what would be the scope of adjudication here? Now, my lord, here the question of adjudication would be, my lord, whether, my lord, what is the term of the contract? How is the contract to be interpreted by application of law? How would, my lord, Section 55 apply? How would the doctrine of reasonable, my lord, period apply? And my lord, all these things will then have to be decided with the NCLT. With the greatest respect, NCLT only decides on, my lord, adjudicated, determined debt and default. My lord, that therefore, my lord, would not be within its purview. And my lord, it is in these circumstances, the NCLT said, I can't decide these questions. And my lord, therefore, Section 8 application was allowed, saying that go to the arbitrator. If he decides this, come back and then I can proceed. Okay. Now, my lord, that was on the question of default. So, my lord, what I'm citing this judgment only for the proposition as, my lord, what would be the domain of consideration for the NCLT? The NCLT can't really get into these disputes. Now, my lord, so far as this... That's right. That's right. Now, my lord, so far as this is concerned, my lord, this is...
How much time will take, Mr. Shah?
My lord, half an hour. I know, half an hour, my lord. I'm sorry. I was a little late, my lord. My apologies.
No, he has already argued.
Yes, my lord, just my lord, the other judgments. So I'll not repeat, my lord.
But my other fixed matter is there. Can you come at 2?
2 o'clock.
I'm not free at 2 o'clock.
Then Mr. Sarkar will not be available.
Gopal Daud.
I'm told Mr. Mukherjee wants to argue also.
He will also argue.
Kindly take it tomorrow. I don't know what the
tomorrow fix
list is like.
ये जो मेंशन किया था दत्ता जो मेंशन किया 2 बजे दूसरा फिक्स है कल वो मैटर फिक्स है आफ्टर 12 tomorrow 12 noon से ना तो उससे पहले तो वो नहीं है 12 noon South Point है that Mr. Sai is also there. Day after tomorrow then.
Tomorrow?
Day after.
But I'm not free day after tomorrow.
When you will be, when Mr.
Let them finish, or if
okay, then let them finish. Let them finish day after tomorrow. I guess first new motion matter.
Well, may I just file my supplementary affidavit? This only brings on record the payment of the interest. I've already served copies.
Consul for the plaintiff has filed affidavit, supplementary affidavit. I was serving the copy to consul for the defendant. Let the same be copied the record. Consul for the plaintiff in reply argued at length, but due to paucity of time, hearing could not be completed. List the matter. आज कितना तारीख है? 31st. 31st. As new motion at the top.
But I will not be here. My colleagues.
Let they complete then.
Could it be, my lord, in the second half? Day after tomorrow?
After tomorrow.
My lord, because my lord, first of all, I'll be very candid, my lord. Very contested matters, my lord, fixed before the NCLT. If I don't go, my lord, there will be a lot of noise made.
Day after tomorrow कोई time है?
The Friday could have
My diary is
Can you take it on Friday, my lord?
Friday. That Friday is 1 तारीख. 1 तारीख को भी non-commercial. Morning भी खाली नहीं है. After lunch, my diary is totally packed.
I know. আবার ওখানে 11:30 একটা জগদম্বা বলে একটা আছে, সে কোন যাবে? আমি সেদিন অসুস্থ ছিলাম বলেছি,
বলো কালকে নিতে পারো না, শেষ হয়ে যায়।
কালকে সময় নেই কোর্টে। I have to difficult.
My diary is totally packed date-wise.
My lord, otherwise I can conclude, my lord. I'll take 5 minutes. My lord, I made the mistake, my lord, of not making the submissions today and waiting for my lord.
No, well, I'll come whenever it's convenient for you, lordship. Well, I shall take care of my other
Okay,
business.
come on 31st.
Very well.
If not, Mr. is there.
Yes, my lord. I shall, my lord, take care of that.
Continue. And
Don't-
let you complete, then we'll see through
Yes,
that. And
my lord. I'll take care.
Mr. Mukherjee will also.
My lord, I will, my lord, whether I will or not, my lord, my colleagues will be here. Kindly, my lord, my lord, don't do matters, too many matters anymore. It's too much for me. Let's see, my lord, what happens.
Okay, day after tomorrow at New
I'll
Hospital.
try
Very
to
well.
join the-
Grateful.
If not, Mr. Mukherjee will also.
Yes, my lord. I will come. I will be there. I will be there.
No, I'm not.
Friday also.
No.
Friday evening, right?
ঠিক নেই
তাহলে করে দাও, Tuesday করে দাও।
করে দাও ভাই, ওরা আছে, ওরা করে এখানে চলে অনেকদিন ধরে।
Yes, next.
My lord, small indulgence, my lord, before you take up the fixed matter. My lord, yesterday I prayed before.
Let the fixed matter come, then I will.
My lord, I just need a leave, my lord. Yesterday I have indicated that deeds are in Hindi, my lord. So the leave is required for the commissioner to affirm the same.
For what?
My lord, all the deeds which were supposed to be annexed is in
Affirm it.
Hindi. My lord, without the leave of this court,
Leave
because
it
the
granted.
deeds are in Hindi, my lord.
Leave
That is.
Yes.
Get deposition. The deposition.
But my learned friend was making submissions. That's why I'm quiet.
Lordship, the enter, just to recap once. The enter situation, it was unregistered deed. I was there in the possession prior to 1956. Then Lordship, 1956 Act came in. Unregistered document was there. Then the Act changed to 1997,
Yes.
which enforced from July 2010, 2001. And then Lordship, their eviction. So my endeavor is to show before your Lordship that by interpretation of the statutes, as well as from the document, it clearly shows that what was the intention of the parties to continue. Now, there was a written agreement. In the written agreement, there was no particular time to terminate. So, when I was entering into contract with them, their particular act was existing 1956. And I was aware that this act is protecting me. I am not registering the instrument and there is no termination clause. Now the statute change that to come out of the premises tenancy, you have to have a registered document or your amount should be within. So now, when the new act came, they have not entered into a fresh agreement with us. That is no one's case that I called upon him for a fresh agreement. Now, by operation of statute, whether my particular act or the protection which I have, that there is no fixed time of termination except on breach of the contract. The question remains whether except for breach of the contract he can terminate me or not. He says since 1956 Act has gone and now you do not come under 97 Act, you come under Transfer of Property Act. So your protection goes monthly tenant, by a notice, terminate. I need not to give any reason. I don't like your face, terminate. Correct. So that's his simple. Now, Lordship, my endeavor is to show what is the effect of that agreement which did not contain, no, not registered, did not contain the clause of termination. What I am trying to establish before your Lordship, at best they can pitch their case that the tenure will not be fixed when there is a written agreement but not registered. I became a monthly tenant. Correct. This much of law is certain. Now what I am trying to argue is month by month I will be governed by my.
So that's why you have vacated the premises. You have vacated the premises, correct? So the first part has gone. Now only with regard to the main profit, whether it is the rent or the main profit. As per your case, you are telling that there is no termination agreement. And the date. And that's why date. So that is
my endeavor will be to show that the termination notice was bad. Because moment he established his termination notice, as if I'm trying to fight out the case, as if I'm in possession.
If suppose the termination notice is declared as a null and void,
then means I have left the premises.
You left the premises.
Then there is no main profit.
That's why the main.
The termination notice is correct.
Termination notice come from where? There are two aspects. Whether the agreement is valid.
Yes.
Whether the agreement is valid or the due to the amendment of the act, agreement goes.
No.
If agreement goes.
No. What they are saying is agreement. They are not saying agreement is invalid. They have exhibited and it's an admitted document between the parties. They are saying whatever agreement I have, but since you are only governed by 106 Transfer of Property Act, so your termination is on my suite.
Okay.
And I am saying since the agreement is agreed by the parties, agreement, this Contract Act is in addition to the Transfer of Property Act. In this case. So, whenever you will come to the termination clause, then you have to show that these breaches are there.
So, you mean to say the agreement, there is no term is mentioned?
Term is mentioned, but term, he will get the term from the act itself.
Act itself, if it is a breach.
So, term I am not now challenging. What I am challenging is condition of that breach.
Condition of?
The condition for termination will remain from the agreement. So the sweet wheel of terminating under the statute will not.
So that's why
the statute will now be camouflaged with this agreement. So he has to say that I did not like your thing. Agreement is also this, and therefore I'm done. So only which I will go, I will lose because of this 1956 Act gone. I will be only losing the tenure protection. But the breach will be limited to the.
Yes.
So suppose he wants to terminate me, 15 days notice he has to give. If it is not given, forget. So he has to show that I am terminating because of the breach of the agreement.
So that's why
Because my agreement
question
cannot
is- your
override the statutory effect.
that's why your question is that there is no breach.
So I have to test the breach.
Correct. You have not mentioned the agreement and in the notice, and this tenancy has not been terminated due to the breach of the contract.
Right.
So that's why, and the contract does not provide the time limit of the tenancy period. So that's why the notice is bad in law. This is your contents.
So Lordship, to establish that, I have to take help of the evidence how they have deposed before the court.
Okay.
But prior to that, Lordship, I have to see the Premises Tenancy Act of 1956 once. Because the agreement was made in that. এটাই তো। জজ সাহেবকে দিই? এটা 1956 Act, Tenancy। 97 টা থাকে, ওই জন্য আমি এটা দিই।
नहीं पुराना नहीं है। पुराना नहीं मंगाया था, क्यों बोलता एक मैटर किया है। यस
Lordship, kindly see the definition of tenant there. And then the
यस
Lordship, kindly see T also. Section 3.
यस
Now, Lordship, I will read section 3 for that. The provision related to the rent and provision related to 3. Definition to the provision related to rent and the provision related to 3136 shall apply to the premises held under release for a residential purpose of lease himself and registered under the Indian Act. Such lease has been entered on or before 1948 and the lease for a period more than 20 years and save nothing shall apply to any premises held under a lease for a period of not less than 15 years. Now, Lordship, kindly see section 31 and 36. What is 31 and 36? The old Act. এটা old তো?
Practical.
31.
What page?
यस
703.
31, Lordship. 703. ওখান থেকে বলো। Lordship, kindly see whatsoever without the previous written consent of the controller save for the purpose of effecting repair comply with the municipal requisition willful disturb any easement annexed to the premises or remove destroy render unserviceable anything provide for the permanent use thereto or in interference with the supply or service of the compromise in the tenancy of such premises shall on comply of the party agree is liable of the first occasion to a fine of this. So Lordship, kindly see except 31 and 36, that is the essential services and the essential repair. 31 we call it the essential repair.
Yes.
Because on the means in all other cases section 3 is applicable.
Yes.
Now Lordship, kindly see section না 31-36 দেখানো হয়েছে। এবার তুই আমাকে দেখাবি হচ্ছে টেনেন্টের ডেফিনেশনটা পাবে।
Yes, next.
Tenant's definition, Lordship.
Therefore, that is 2F, I think. So.
2.
First.
Eight 670.
2H.
Yes. Means any person by whom or whose account on behalf the rent may premises for a special. Lordship has got.
Yes, yes.
But for a special contract would be payable, including any person contained in possession after termination of a tenancy, or in the event of such person death, such of his heirs and ordinary residing with him at the time of death, but shall not include any person against whom any decree has been passed and eviction has been passed and such and such. So, Lordship, the thing is, whoever render the rent, he remains as a tenant under 1946. Now, Lordship, kindly see 1997. Lordship will find whenever there is a pending litigations, section 45.
Yes.
Roman 2. Notwithstanding such repeal, all suits and other proceeding under the said act pending at the commencement of this act before the court or any court shall be continued and disposed of in accordance with the provision of the said act, as if the said act continued in force, provided that the provision of the appeal under the said act shall continue in force in respect of the suit disposed of there. Provided further that for any of the purpose of the said, the controller such and such has been deemed to be the rent controller or additional such and such, and the proceedings include any appeal, review, revision, application for execution, any other proceedings whatsoever under that, any other proceedings. Now, Lordship, kindly turn to 106 and 108 of the Transfer of Property Act. Lordship will kindly take note of the word written contract. This part has been dealt by the Supreme Court, said written contract means registered written or a local usage. So Lordship will not take note, or Lordship rather will take note of a fact. When I entered into a written agreement, that point of time, my local usage and local law was with me. 56 Act. And that point of time, 106 was also available.
Yes.
So, if an agreement entered upon by the parties on a local usage or the local law of that time, because when 97 came into force, I was not governed by that. So, my agreement under the previous statute reduced to the factor that it was a local usage at that point of time. Because I am not entering into premises anymore, any further. 1997 Act, because the cap is there, 6,500 and 3,000, so I'm out of the cap. So, on the date of promulgation means on 10th July 2001. What are the things applicable to this contract? A agreement entered upon the parties under local usage and 106. Now 106 is accepting the agreement within. 106, the statute recognized that agreement. So what I tried to argue, that we said that the previous agreement has no effect, cannot. Now I will read the section. In absence of a contract or local law or usage of the country. So, Lordship, in absence of a contract, I had a contract.
Yes.
Contract was there.
So you are admitting there is a contract.
Yes. Now both parties have admitted.
Okay. Then.
So contract is admitted. Contract is recognized in the statute.
Okay.
Or of a contract or local law. At that point of time, I had the local law. Or usage of the country. The lease of immovable property for agricultural manufacturing shall be deemed to be a lease from year to year, terminable on such and such, a 6-month notice, and a lease of immovable property such as shall be deemed to be a lease from month to month, terminable on this such and such by the 15 days notice. So the contract is recognized even in on 10th July 2001.
Yes.
Then why I'm repeatedly saying 10th July? Because that time 1997 Act came into picture. Notwithstanding anything contained in other law for the time being in force. Next. So this is not in derogation of other law or contract. This is in addition.
Yes.
The period mentioned in subsection 1 shall commence from the date of receipt of the notice.
Correct.
The notice under subsection shall be deemed to be invalid, shall not be deemed to be invalid merely because the period mentioned falls short of this under where a suit or proceedings is filed after the expiry of the period. Where a notice under must be in writing signed by such and such and give it to either be sent by post or by such and such, intended to bound on with such and such, delivered personally to such or one of the family members of such and such affixed to this. The provision of such and such principal act and then amendment section 2 of the transfer of the notices such and such and then the notices, Lordship. Now, Lordship, kindly turn to the evidence of the plaintiff. Lordship, paragraph 2.
Paragraph 2 of
Affidavit in evidence. Affidavit in evidence.
yes.
Lordship will also take my cross-examination. Lordship, the first thing is, this man who was deposing is of the knowledge since 1996 or must have consulted the record. Lordship will kindly see my agreement is of 1984. Plaintiff is the major portion only. Then, Lordship, agreement, kindly see with regard to the agreement, his stance is para 5.
Yes.
PK joined general manager of the plaintiff and got acquainted with the signature of this, such and such signing the agreement. I have not got acquainted with the signature of Asa and from the record of the plaintiff. Such agreement has been a map of the premises appended thereto, the same condition of the signature such and such. On behalf of the content of the said agreement true and correct, I tender the agreement 7 May 84 same as this. So, Lordship, he enters the agreement. Although the initial rent was 72,000, which was calculated 6 rupees, the said agreement provided there should be a 10 rupees, such and such. Further agreed that the maintenance charge will such and such, such and such. According to the said agreement, defendant has also obliged to pay and reimburse the agreement, occupy a share of tax, including such and such, and urban taxes, such and such, outgoing as the imposed by the central government or by the state government. I pause here for a moment. Kindly see the date of the deposition. Date of deposition is 2024. Now he says that according to the said agreement, the defendant was also obliged to pay the reimburse the occupier shares. At that point of time, I was tenant. Now, although the said agreement provided that the monthly tenancy shall be governed by the West Bengal such and such, the following enactment of such and such, the suit came into governed by the provision of the such and such. The reason being that the rent paid by the defendant was for far above the ceiling of the West Bengal Premises Tenancy Act 1997. So when I agreed, that was applicable to us. Now he says, now it is above the ceiling you are. According to the plaintiff, issued a notice dated such and such for the termination. Now, Lordship, kindly see. The chief examination in chief and the cross. I will take that affidavit in chief once more. Lordship, kindly come to question number 31 in the chief.
31 in the chief. Paragraph 31.
No, question number 31 in the chief. Which my learned senior.
आप serial क्यों नहीं रखते?
May I hand over my copy?
No, it is there. Yes. Serial क्यों नहीं रखते? जैसे उठाया रखा.
I am showing you a copy of the order dated passed by the Honorable High Court. Kindly tell my lord what is this? Is an order of Honorable High Court in GS such and such in CS between the plaintiff and the National Insurance. The order dated this mark for identification. So, Lordship, I am showing you a document dated 8th May and 20th May 2000. Kindly tell. This document was written by Amitabh Chanda, Assistant Manager, Company, regarding payment of the rent for the month of 2009 in respect of the Subpoena. The first letter 8 May forwarded a check of such and such to the plaintiff company. Another letter such and such written by and apprised by the court who is the owner of the premises. So, defendant company forwarding here with the payment of the rent. Did you receive this check? Yes. Where this letter received by you usual course? Yes. So, Lordship, kindly see. Lordship, kindly see. So, till 2009, he received the money. So, what he was governed by this? 10th July 2010 to this 2009. He was governed by this agreement only. Month by month, I will not get the effect of the tenure. But month by month, he has agreed and he deposed in chief, not even in cross.
Yes.
Now, kindly see what was the date of the termination letter. Lordship will see the date of the termination letter is 19 July 2008.
July
2008. Yes, ma'am.
Yes.
My lord, that is page 12 to 14 of the judge's brief.
Yes. What is the exhibit?
Exhibit number. কত নম্বর দেখো? Termination letter টা কত exhibit?
Exhibit B.
Exhibit?
B.
Yes.
So, Lordship, termination
2008.
8. And this is his own admission that he received the check and the money, and which he clarifies. Lordship, I am still in chief. I have not entered cross. So he received the money
2009.
2009 for the rent.
Yes. What was the month? What was the month of the rent?
May. 8th May and 20th May.
No, letter dated 8th May and tender.
And dated 8th May and 20th May.
What this says? Exhibit. Show the exhibit G and H. G and H.
Exhibit G and H. The exhibit G. Judge's brief of document. Right. Your Lordship, kindly see the language. Please find
being the rent of May 2025.
Yes. Dated check number for Ato drawn on bank such and such. Payment of the rent as per the court order dated 30 court order dated 39. The detail are given below.
What is the court order?
Lordship, court order is marked for identification.
Why the court order is my identification? Court order must be exhibit. Identification or high spend. Identification. Expert.
Abhishek,
30th April 2009.
The notice dated such as the regular tenancy has been terminated. In spite of such termination, the respondent will continue in this. The occupied of the such building without payment of any sum sought to be instead of filing the instead of it. The counsel for the respondent stated that after the notice of the termination, a sum of has been equivalent to the rent was offered to the petitioner, but for the reason best known, the petitioner refused to accept the same. Therefore, the question of depositing rent with the petitioner does not arise. Provision of the local law are not applicable, and therefore no direction for payment as made in the suit has been filed before issuing the notice under section this. The transfer of property does not contain any provision for deposit of a sum on an account of a rent or occupier charges after the
Without prejudice to the rights and content, both the parties also responding right to make the payment.
That means
without prejudice.
Right. Yes. So, Lordship, kindly see. Without the direction, the the paid by paid, there is a clear that the petitioner will continue in supplying the amenities to the respondent in the thing, such and such agreement. Lordship, kindly see this application was made for the deposit of the rent. So at that point of time, what I'm saying is when two aspects of it, they receive the rent as per the court order, as per the last rent.
Correct.
Lordship, and then what I have done is, Lordship will find throughout the tenure, I have kept on increasing that 10%. Lordship, I am in the cross-examination, I will take you. Then, Lordship, I have increased my 10% as per the agreement.
No, increase it 10% after this order. After this order.
I will take you, Lordship. So, Lordship, this order was initially there.
Correct.
Then, Lordship, I honored the agreement.
Correct.
And he accepted the agreement.
Correct.
During pendency of this.
Correct.
So, if these two are given effect together, then Lordship, we will try to ascertain whether the termination and thereafter.
That's what the order can specify without prejudice to the rights and contention of the party.
Yes. Yes.
If it is there, so you cannot raise that point now.
No.
You cannot paint the point.
No, had it been the amount remained same all along, then this point is not available.
Correct.
Moment I have started increasing the rent in view of the agreement, 10% per, there was a clause that 10% it will increase. If I can show that I increase the rent and they kept on receiving, up till this particular quantum, they are protected by the court order. But after that, if I increased it as per the previous agreement and they accepted it, then there this protection goes. That's what my argument.
Okay.
Then that means the earlier agreement they are giving effect to.
Yes. 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 Next.
Now, Lordship, again we will come back to the cross-examination. Lordship, cross-examination. First I said, whether do you have a board resolution to that effect? He said, I don't know, must be in that record. But of course, that is there or not, Lordship has to see. Now, Lordship, kindly come to question number 43 and 46.
Cross-examination.
Yes.
Yes.
Lordship, I tried to ascertain from the gentleman how old is the building.
43.
Yes, Lordship. First 43.
Yes. Yes, next.
Next. 47. Is your evidence that before execution of your agreement such and such, the defendant was in possession of the property?
Was not in possession of the property.
Was not in possession. The defendant was in property.
Correct.
Because, Lordship, it was Turner Morrison, National Insurance.
Continue.
So we were there on a special arrangement. The litigation was going on, and by virtue of settlement, the new tenancy was created. Kindly see, it is even before 1956, I was there. So the litigation was going on between the parties. They settled it. Now, Lordship, when the new act came, they tried to. Now, Lordship, kindly. 56. Since 1963,
Just a minute. 56.
56.
Yes.
Can you apprise the Honorable Court since when the predecessor in interest of the national insurance was in possession? Since 1963, the predecessor in interest of the insurance was our tenant and was terminated by virtue of the settlement of the new tenancy and created in favor of this. So it was a continuing arrangement all along.
Yes.
Then is it your evidence that the present defendant was in possession? While being in possession, the defendant made an arrangement with the plaintiff to continue the tenancy? 57. This is a subject matter of record. This is mentioned in the tenancy agreement because the tenancy agreement itself acknowledges that I am in possession. Is it your evidence that the relation between defendant and the plaintiff will be governed by this agreement only?
So what is your argument if they are in possession prior to this also? What is your contention on
Lordship, I will take that local usage and the local contract part. I have to show that the local part and contract was existing much prior. So the agreement clauses will remain. My only endeavor has to establish my agreement to govern the relationship. I have to show the tenure will go away, but the clauses of the breach, because his termination not only has to be a termination notice, then he has to show that there was a breach.
Correct.
So to show and establish that, I have to examine him, because what is my case? In a carapiat judgment, I have to put my case in a cross-examination. So exactly what I am trying to say is that local law and the usage was there, and it was an arrangement because my predecessor was there. So you gave it to me. So today you cannot turn your face and say, only I will say up to 106 of TP Act. I will not say anything beyond that.
So what is a written statement?
Written statement is also that the earlier act was applicable.
What was the defense in that?
Some defense, but this much of law was not expanded because I have expanded that scope by my cross-examination. To be very honest, Lordship, this explicit way they have not taken. They said we are protected by the earlier tenancy of 1956, even though it has gone, but still we are protected by that usage and the local law of that time. That much is taken there. Now in the, I was not there in the written statement. So Lordship.
So you know very well. Pleading is necessary.
Necessary, but then I have a source there. Then I have explained and expanded that in my cross-examination.
Okay, continue.
And Lordship, now let's see, I don't have a written statement that they can pitch their case that high. So even that case, agreement is admitted by the party, my cross-examination right will remain, and the law I will interpret. Because Lordship is today not really hearing eviction of the tenant.
That's not only the validity of the notice.
Validity
if it is
of
validity,
the notice, vis-a-vis whether the agreement clauses are
correct.
If that is a small
that
point.
is the two things.
If the agreement is applicable to my case, then the termination notice even valid, but has to refer to the breach.
Yes.
So this is the only thing I am trying to demonstrate before your Lordship. Now, Lordship, now that's why I have done
so that is admitted. There is no reason for the 106. They are not mentioned with regard to the 106.
So my previous local usage condition and the law agreement has to be now on record before your Lordship.
Correct.
Unless I bring it on record, I cannot argue that 106 has to be read along with that. So to bring it on record in the cross-examination, because by written statement, even if I have said But if I could not prove it by my own witness or by cross-examination,
No, sir.
no purpose would have served. And even if I don't have a written statement, but if I can bring those facts by cross-examination.
Okay, sure.
Lordship, then, they have paying the rent since the date of commencement till, Lordship, kindly see 58. It will be governed by the agreement.
Page. Question?
Question 58. This is
Yes,
this is the question I will read.
Correct.
Is it your evidence that the relationship between the defendant and the plaintiff will be governed by this agreement only? It will be governed by the agreement as well as by implication that the national was our tenant. They are paying rent since the date of commencement of the tenancy till they surrendered the possession to us. So 58, he categorically admits, yes, the agreement is governing us, and from that day till the surrender, he paid us rent.
Yes.
So, Lordship, this 58 clearly shows that the agreement they are adhering to.
Yes.
And the rent is not due.
Yes.
Then I said, what was the Corporation of Royal Exchange Assurance? They were my previous tenant and the predecessor of mine. So I am showing the common law and usage.
Yes.
Did you file any suit before the High Court at Calcutta against the Corporation of Royal Exchange? Yes.
Yes.
So the agreement was pre-will and a agreement between my predecessor and them to avoid a litigation. Kindly see this. It has got two aspects. One aspect is they litigate with my previous predecessor.
Correct.
They settled the matter.
Correct.
So whatever the terms is freezed and enter upon and reduced to writing. It is a conscious decision of the party prior to the suit. So the bargaining was like that because the suit was for eviction. So obvious, they wanted to evict, I wanted to remain. So we compromised in a way. So that's the reason why there was no tenure given.
Okay.
In fact, in the year 1983, the national was in possession of the suit property because by that time it has become, and not the Corporation Royal Exchange. Initially, the Corporation of Royal Exchange Assurance was the tenant, and we filed a eviction suit against them by virtue of agreement dated such and such. We created fresh tenancy in favor of this. So he filed a suit against my predecessor.
Admitted.
What's the effect? There is an effect. If a suit is already filed, then Lordship, on the ground, it is not a premises tenancy law that every month a fresh cause of action. For him, if the certain breaches was done and then the new agreement, that means all previous breaches novated and now they are into this. And it was a usage and the customs that they reduce into writing.
Correct.
Now, Lordship, kindly turn to the next. (64). Can you apprise the Honorable Court that what was the fate of the suit being numbered not such and such against the present defendant? Against the present defendant, they also filed. I have already answered the question earlier that the dispute was settled between the parties. So 83, title suit number 661 of 1983. If you Lordship see question number 16.
Yes, I want.
So they said that 1983 there was a I'm asking whether the suit is pending, disposed of, decreed in terms of settlement. I do not have any record in my company available with me. So he did not say it is dismissed. If it is dismissed on a ground, whether it will be a res judicata or not, nothing is before your Lordship. But there was a suit against me for which I settled by a new agreement.
But if you got the answer, in kindly come to the 62. You got the answer from the witness. That was amicably settled and a fresh tenancy agreement was created.
Right.
with
So
anything else.
moment a amicable settlement is done,
Hmm.
then the suit has to also go to a logical conclusion. If a Lordship kindly see, suppose he filed a
Sir, a person on the dock who is a layman on the law, he cannot say whether what is the decree, what is the plaint. He has stated that it is settled, it is settled.
Then he has to.
He cannot say settle with the compromise decree.
Nothing. I
So
only asked what is the fate of the suit.
Correct.
As a
Now
layman, he
kindly
can
come
say.
to the 66. The suit is not pending.
Yes. So that means then what I said is kindly came 60.
66. The suit is not
65.
pending. 65. I do not
65
have
he said,
any,
I don't have the
any record.
disposed of, pending or decreed.
Correct.
So now what I'm saying is, order 23 will stare at the face. Even if I entered into an agreement with my learned friend on an issue and I did not pursue my suit, suit is dismissed for default or suit is dismissed for otherwise, that order 23 will remain against me for my subsequent suit. So, Lordship, today he said that yes, there was a suit. I entered a fresh agreement, I left that suit. I abandoned that suit.
Correct.
So, the fate of that suit will have a bearing on the present suit from the viewpoint of order 23.
Where is your written statement to this effect?
No, Lordship, there is no.
Then how you can plead that?
No, this is a pure question of fact and he admitted on doc.
Sir, once you, in your cross-examination, it is stated that it is amicably settled. What is meaning of that? If the witness on your cross-examination, witness is telling that the matter is settled and fresh agreement was entered and you are harping upon that agreement in this suit, what remains? Pendency of the suit, what remains? You tell me.
Lordship, what I'm
saying. If you acted upon.
On the this fresh
agreement.
Yes,
and you are harping upon this agreement in this suit.
Lordship.
Correct.
Lordship.
And you have not taken in the written statement that suit is still pending. This suit is not maintainable.
Lordship.
How you can argue at this stage?
True, Lordship. About on.
Then?
But I was just thinking otherwise, if your Lordship kindly think that first suit is for recovery of a possession.
But and one thing also you to see, this agreement is not a part of the decree of this earlier suit.
That's
Please
what I'm saying.
Keep it in mind.
That's what I said.
That's what I'm telling you. If it is not, that's why not a decree, not a part of the decree, this agreement. And the question you have brought in your cross-examination 62.
That's what I'm saying. What I wanted to get out of it. Since I am not registered, if this settlement is this agreement is the fruit of as if a settlement decree.
No.
That's what my endeavor was to cross-examine. If I could get that, yes, this is a part of the settlement decree, then Lordship, my hurdle of registration goes.
What? My lord, I did not want to disturb my learned friend, but there is just one paragraph of the written statement I would like to draw your lordship's attention to. Paragraph 14.
Written statement. Written statement.
পেয়েছেন আমি কপি দেব
Page, paragraph?
Paragraph 14, page 7. With reference to paragraphs 9 and 10 of the plaint, it is stated that this defendant was liable to vacate or hand over peaceful possession of the suit premises to the plaintiff only upon the expiry of August 2008. That is the date of the notice. So after the expiry of the notice period. So what remains after this admission? I really did not quite follow the submissions sought to be made, but I will deal with them later on. There is a clear admission he was liable to vacate, and he did not. So the date of calculation of mean profits will start from August 2008.
Yes.
Notice period expired on 31st July.
Sir, I have seen that. I have noticed. That's it. Because if we read the whole paragraph as a whole, there was a denial, but then
Okay.
that denial has.
Okay. How much time will take? You have to complete one day.
But if I need another half an hour or 35 minutes, so I will complete it. Almost I have entered to the cross-examination part, Lordship.
Counsel for the defendant.
Lordship, except 4th and 5th August, I will be out.
Counsel for the defendant has argued the matter at length, but due to paucity of time, argument could not be completed.
अगर वो नहीं
Please the matter. Date आ जाएगी? Please the matter. सितंबर उससे पहले कोई नहीं है. Then I am giving two. How much time you will take, Mr.
Half an hour maximum.
19th August at 19th August at 12:30.
19th August 12:30.
19th August 12:30.
Complete
I
on
know
that.
I'm a very difficult footing, but
No, not that. But not. This court never made up the mind till the delivery of judgment.
I'm prepared.
But
Grateful, man.
whatever the confusion is coming, then it is a bad habit of the court to put
No,
the
no,
question.
this is always better than we prepare. I'm different.
Yes.
Well,
My lord, with your lordship's leave, I want to file my additional judge's brief, lordship.
What?
Additional judge's brief of document.
we asked for a copy.
We have served, sir.
Okay. No, not sir.
सब नहीं क्यों?
No.
दिखा रहे सर.
Yes.
23rd July serve कर दिए सर. We have already served on 23rd July.
Extra copy make
अच्छा रखो extra copy हम लोग.
Yes, any report has come.
ठीक है सर. extra copy लग गई ना रखो लग. एक extra copy है तो दो ना. Definitely.
Fine. Bulao.
Thank you so much. Thank you so much.
To both persons.
Abhishek,
Both have come. Both have come. Who has come?
Still value को तुम cross करेंगे ना. Still not Ranjit Chakraborty.
Yes, one is present of the bailiff.
The judges will fill.
Ranjit Chakraborty, seal bailiff.
Lordship. तुम्हें अपनी करना नहीं को.
Yes.
My lord.
First. Now, who has challenged the notice?
They have challenged the notice.
Then you have to cross.
Even though I'm ready with my questions, your lordship.
Now he has challenged, then he has.
Because your lordship, if you will see,
আমি এই মামলায় সাক্ষ্য দিতে এসে যা কিছু বলিব সত্য বলিব সত্য ছাড়া মিথ্যা বলিব না কোনো কিছু গোপন করিব না আমার নাম রঞ্জিত চক্রবর্তী
दूसरा का नोटिस क्या हुआ पोस्टल वाला का
लेट सुशील चक्रवर्ती 49 court employee was residential address শিমুলতলা, ভিলেজ শিমুলতলা, বনগা, yes, post office বনগা, হ্যাঁ, আর ডিস্ট্রিক্ট নট 24 পরগনাস।
जानले এটা रिफ्यूज किया वारंट कर दे वारंट क्या जजेस ब्रीफ था ना ये फाइल कर ये ना
Witness, please tell my lord the description of the place where you served the summons. Can you describe it? For example, there was a small gate or a wide gate, or as you enter, whether there's office or there is no office.
My lord, first of all, please accept my humble respect. I was handed over a copy of the report prepared by me from the office of the sheriff, and the report reveals that I reached the registered address of the limited company and registered address of the limited company and served the writ of summons upon to the defendant, a person to represent the defendant.
Was to a person who represented the
Do you ask the name of the person?
He put his name there.
Can you read it?
There on the writ of summons.
Can you tell his name to the court?
So I cannot say it, but their the name there.
I cannot read, but his name is there.
Oh, very well. So you don't know his name.
I don't know his name. The name, so far my knowledge is concerned, he is the security in charge. Actually,
so far as my knowledge, he is the security in charge. Full stop. Then
first, I was introduced to one of the principal officer in the office, and he refused to put his name and written statement. He get the summons, writ of summons received by his security, and I know the name of the principal officer. He only disclosed his name Agarwal. I have stated in my report.
Very well. Can you find a stamp just below the signature, and for Joyju there is a stamp there?
The security in charge disclosed to me that the defendant company changed his name, and the new company, he put the seal of the new company. And he put the written statement that he received the writ of summons for Joyjut and Industrial Limited.
But he doesn't belong to Joyjut.
I cannot say. He acknowledged before me.
But the stamp reads some other name.
Evidently some other name, but he disclosed that this is the name of new company.
It didn't occur to you that somebody signing for X and giving a stamp of Y is irregular?
He said that the seal of the new company, old company is not available here. That's why he put the seal of the new company.
Very well. Then he should have put the stamp of the new company.
New company, yes.
But then he could have signed on for in the name of old company, old name.
Yes, he did so.
How can you allow a person to sign in two names? ও যাচ্ছে না। I think, my lord, in electricity tribunal others, instead of writing down, they do it in a by video camera. And system is even have absent. I have to apply in the morning, pay fees 100 rupees. In the afternoon, I get a copy of the CD of the whole recording.
For that purpose, I request all the senior members of the bar to collect the amount and give to the IT section. So that can be improved.
Actually, this taking down is, I mean,
Now, even though in the other high courts, in the original site, it is the duty of the registrars. If it is come to the evidence, it will go to the registrars, and registrars will record the evidence
place it
and will
before
place before them. But
that saves
system
court
is-
time.
the same system is not here.
Here.
That is the problem.
The rules should be amended.
And second thing, if not the recording also, it can be directly dictation.
Yes, it's direct
Mouth
dictation.
to machine.
Mouth to machine. Yes,
It can be directly.
yes, yes, audio recording can be there.
But that is also not there. You know, Mr. Sarkar, what is our
Your Lordship,
finding?
Lordship, now I think it is getting recorded, his submissions. Because it is very important, Lordship. My client is suffering just for, they have not
Okay.
appeared now.
Who is suffering? There is still a question. Now, so Mr. Chakraborty, I put it to you, you could not have signed a person to sign in two names, on behalf of two companies. You find there are two companies. Please look at some signature for Jayajut, and the stamp is something Gajmukh something. I cannot read properly.
Actually, he acknowledged that he represented the independent company. That's
So
why-
pausing here for a moment. If the name has changed, then how could have said that he is accepting on behalf of the old name?
Just a minute. I will cut.
Lordship.
Said there,
Okay, you give the answer, then the court. Yes, give the answer.
there is a written statement that he is receiving the writ of copy
Written
of
statement or writ of summons?
writ of summons, and along with 4 volumes of documents for Jayajut and Industrial Limited.
But he used the stamp of some other name.
Yes, he acknowledged that the old seal of the old company is not available here. That's why he put the seal of the new company.
Very well.
Okay. What you personally went? You personally went to serve this
Yes,
writ of
yes,
summons?
sir. Yes, sir.
If you found that one company, the writ of summons is in one of the company, and you came to know the name of the company is changed, but in the writ of summons, the name of the company is different. What is your duty?
Sir, actually, we have no training about the service of writ of summons. So far my knowledge is concerned, as I reached the registered address, one person represented the company, and he
And you have served the copy to them. Okay.
Now coming back to my first question. Can you describe the place where you entered?
Sir, I am unable to describe it. I have
You went
stated-
there. You went there?
Went there. I personally went there.
Very well. Then you cannot describe the place.
I have stated the facts and events happened on that day in my report. But
That
I
we have
cannot
seen,
say
but that we are not happy with that.
other কিছু আমি এখন মনে করে বলতে পারবো না।
I cannot remember anything.
You visited a place you cannot describe.
I mean, everything I have stated in my report.
No. Many things you have not stated.
জায়গাটা মেনশন করেছি।
Can you at present you can say with regard to the location of the place?
I cannot recall
I
it.
cannot recollect. Yes.
Now, have you seen any document that the name of the defendant company has changed?
It is I asked him to show the documents, but he refused to do so. Even being a simple bailiff or process server, it is quite impossible for me to charge him the documents placed before me.
Now, if a writ of summons is issued in the name of X, and you go there, find the name of the X is changed, can you serve the writ of summons?
Sir, so far my knowledge is concerned that it is the writ of summons.
Or it is your duty to return back the summons to be issued in the new name?
It is the summons, sorry, the writ of summons or volume of documents is to be served upon to the company, limited company. So far my knowledge is concerned.
Not
when
knowledge. Mr. Sarkar is putting a specific question. If you found when you went to the place and you found that the name is changed of the company, can you have to return the writ of summons or you have to serve the summons to the other person?
as the person represented to the company, that's why I hand over the writ of summons to him.
My lord, we have filed a petition. May I have it?
What petition? GA?
GA, lordship.
পেয়েছি ওটা
আপনারা এও ফাইল করেছেন।
IAGA 1
IAGA 1
नहीं है. You have what you operate for?
Actually, in front of me, there is a document which will prove that the name has not changed.
Then you can argue that. Your J1 है? You have a copy?
Yes,
J1.
yes.
But it is not listed. तो आपके पास आया है? You can produce the document, Mr. Saka. You can hand over the document, serving the copy to the other side.
J1 na? It is to dispose of na? This J is disposed of.
They can remand it. So
okay, dispose of, then it will not be recalled.
That is
from the disposal, it was remanded, so it should be on.
Okay, no problem. You put if you new document you want, then you which document you.
Mr. Chakraborty, I am showing you a document.
Page sir. Page
Page 15 and 16 দেখাবে। ঠিক আছে, 15 আর 17 হবে। Page 15, can you look at page 15? What is this document? Can you find out?
Lease deed.
Now, between which company?
It is Jaijurs and Industrial Limited. Between
you will admit that Jaijut is the defendant.
From these documents, I admit it.
Yes, next.
Turn over to the page 17. What name is mentioned as the lessee?
Gajmukh Binimoy Private Limited Corporation.
And can you read the name of director here?
Sri Robi Kumar Agarwal.
The person you met, allegedly met, at the time of service, was he Mr. Agarwal?
One person, he disclosed his name Agarwal. As Agarwal.
I am putting it to Mr. Chakraborty. Gajmukh Vinimay is a lessee of the Jai Jute and Industries Limited, and the name has not changed.
Can you say or cannot say? Either.
Not a fact.
Mr. Chakraborty, I am putting it to you that your service report is totally incorrect.
Not a fact. So far my knowledge is concerned, the report is
Yes, sir,
correct.
not a fact.
So, Mr. Chakraborty, no. ठीक है. हाँ? Oh, अब बैठ जाइए प्लीज. So I am putting it to you that you have effected service on Gajmukh Binimay.
No, I served.
Yes.
Sorry, sir. Sorry, sir.
Please. बोलूं.
Have you completed the question?
Yes, my lord. I am putting it to you that you have not served the defendant.
I have served the writ of summons upon the defendant.
Just now,
Sir, I could not understand the question.
okay.
That's all.
Just now you said, I have shown you a document that Gajmukh is a lessee of the defendant.
So the fact was not at that time was clear, but as the person who represented the company, I served the writ of summons upon him.
ছবিটা দেখি কোথায় আছে কোন পেজে না পিটিশন থেকে দেখাই সাপ্লিমেন্টারি পিকচার
Additional judges because
না দেখাচ্ছি you cannot describe the place.
I am unable now. I am unable to describe now.
Very well. How big is the gate from through which you entered?
The gate was large, so far my knowledge is concerned.
You mean large,
But
2 feet,
there was a
10 feet?
I cannot
I see.
mention to them feet.
Very well.
Sorry, there was a small part to enter.
Okay.
Passage.
I'm putting it to you. I mean, before entering this gate, did you inquire there are any other gates?
Sorry, sir. Any other gates mean?
বলতে can I speak in Bengali? Yes. মানে মনে করুন আপনি গেলে একটা জুট মিল তো অনেকগুলো গেট আছে তো আপনি আর কোনো গেটে দেখেছিলেন
লার্জ গেট ছিল তার পাশে একটা প্লেয়ারের একটা প্যাসেজ মতো ছিল এরকম একটা মনে আমার
There was a large gate and beside that there was a small passage.
passage, there are 2 gates, one for Gajmukh, another for the defendant. The passage is only in Gajmukh's gate. He went to different premises, served to different person.
Okay. Yes.
May I show him?
Yeah, where original?
Huh?
Original.
This is filed in the supplementary affidavit.
That is a J1.
So, my lord,
Can't say.
lordship lordship can keep it after few days. Let those papers come because I have to ask some questions on the basis on those documents. If lordship gives us.
Where from you come? Where from you came?
Sir, I am the employee of the Lane district judge, Barsat.
Barasat. Came from Barasat. If you want, I will bring that. That कितना देरी लगेगा?
Well, plaintiff doesn't suffer if he comes after 3, 4 or 7 days.
No, Lordship, my clients are already, they are saying that they cannot bear these expenses, Your Lordship. It has to be concluded and let them conclude their
The
question.
suit cannot be concluded.
No, not the suit.
it's-
This is, Your Lordship, the written statement. If Your Lordship will see the order, everything has been explained. That confidentiality clause, that how this has to be kept confidential. The document which my learned senior just now showed, if you will see the page 23, it is very clearly written, both the lessor and the lessee shall treat this agreement and related understanding confidential and shall not disclose to any other person. Your Lordship, a mere bailiff who is going, and kindly see his report in the, we have already annexed in the judge's, additional judge's brief.
Well, let me finish. My learned friend, we can ask him.
Yes, if you have any other question, you can put, then the photograph will came later.
Photograph is there, हम जिसको दिखाते हैं.
Mr. Chakravarti, how can you ask somebody to write the name of the defendant and put a show him the once writ of summons.
कौन सा है
about the middle of the page, eh? The defendant and put a different stamp. Well, let's see. Jajur below that some Gajmukh something.
I did not ask him to put the seal of other company. I
Why
asked him
do you allow? Why do you serve the summons
not
at all?
in my capacity. He put the seal. When I asked him to put the seal, he stamped this seal, and he
You should have
said
reported that the service is incomplete.
Okay, okay.
that
Well,
this
you put
this
the
is
question, not the
this is the
suggestion.
discretion of the Honorable High Court.
Yes, next.
Can you serve any letter to a company without the rubber stamp of the company?
Sir, I have no training about it. I cannot say it. Our stamp.
What?
That is the problem.
Did you see any nameplate or any registration board or the person who received his ID
I cannot
card?
recall it. I cannot recall it.
Very conveniently I waiting.
এই গাজমুখ বিনিময় লিমিটেড বোর্ড ছিল কিনা যেটা যে স্যার বলতে চাচ্ছেন আপনি, আমি সেটা মনে করতে পারছি না.
I am showing you two photographs. প্রথম একটা দেবেন প্রথম না ওইটা দেবেন. হ্যাঁ, is this the gate where you serve the writ of summons?
Sir, I cannot recall it.
I cannot recollect.
Well, may I tender it, Malad?
Yes, original is coming. I will.
And give me the other picture. একটু দিয়ে দেবেন একটা. Mr. Chakraborty, please tell my lord whether you got the writ of summons service on this gate.
Sorry, sir, I cannot recall it. Which gate I faced.
It's such a written in such a bold, big letter.
Cannot
You
recall it
at
now.
the time of entering, you didn't see.
Sir, I cannot recall it now, as it happened what, 3 years ago.
I cannot recollect which gate I had been to.
Now
Service of
look
writ
at
of
this
summons.
picture very closely. That Jai Jute picture. Do you find any small gate?
No, there is no small gate.
Please show him the Gajmukh picture.
Both have kept side by side.
Okay. Then please see the Gajmukh picture. Do you see a small gate?
Small gate means the a part.
Yes.
There was a part.
So you said when you enter, there was a big gate and a small gate, and the gate of the defendant does not have a small gate, but the gate of Gajmukh, the lessee company, only has a small gate. So I'm again putting it to you, and please tell the court the truth that you served on Gajmukh only.
No, sir. I served the writ of summons upon one person who represented the Joy Jutes Industrial Limited. And
But your description of the gate tallies with Gajmukh and not with the defendant.
sir, the person who represented the old company. That's why I served the writ of summons upon him.
Person who represented there was off from the old company.
And he put a written statement there. And he put a written statement on the writ of summons.
And he put his endorsement in the writ of summons.
Mr. Chakraborty, you will find from the lease deed that the name of director is Agarwal.
No, I did not see that.
It is written in a report.
I am just seeing it, but it was quite impossible for me to
report to the
read the 4-volume
writ of summons. ওখানেই হবে। Can you read from here? Writ of summons.
Yes, it is.
Additional judges brief.
It is with him.
Additional judges brief বলতে আছে my lord.
Original writ of summons.
Original is there, na?
Yes, it is there.
क्या हुआ उसको? नहीं मिला।
No, subsequently.
मानो
Kindly read out from your report
क्या हुआ? नहीं मिला जी।
subsequently.
नहीं हमें ऑफिस में सब बीड़ी पीने गए होंगे।
Slowly read out.
Subsequently, yes, I see it. He is found to talk to some other person, to some person of his upper hand, and discloses that the company defendant has changed its name. It is now known as Gajmukh Binimay Private Limited.
Continue,
However, he represents the registered company defendant, and gets the writ of summons and the connected documents by the security in charge of the present name company.
Then
the acquainted principal officer has refused to sign here. He has just disclosed his, sorry sir, his to be Agarwal, his name, there was a typographical mistake.
Stop here.
Disclose is to be Agarwal.
Agarwal. So you will find that from the lease deed, the director's name of Gajmukh is Agarwal. Do you agree? Lease deed to the
Your lordship, there can be 10 people with the surname Agarwal.
There
Why
was no interrupting. You'll get your chance,
See,
ma'am.
it was,
Please, why
it
don't
was
you sit
quite
down?
impossible
That's
for me to
convenient.
read out the volume of my 4 volumes and serve the.
Not necessary. Only see that the document who is the in this who is the
From these documents, I just see that the director from the list did.
I find that
I just find it that the director is Sri Ravi Kumar Agarwal.
at page number 7.
Kindly read this part after Agarwal. Kindly go on reading.
Pranab Girdhari Lal Agarwal, residing at this.
কোথায় পড়ছেন আপনি? Not least it. I'm writ of summons. The security in charge from there. After the Agarwal.
The security in charge has endorsed signing hereon along with the seal of the present named company. Thus, the service of the writ of summons is made effective.
Now, so you served on Jai Jute Industries or Gajmukh Binimay?
জয়জুট ইন্ডাস্ট্রিজ লিমিটেডের উপরেই সার্ভিস করেছি আমি।
But the stamp and Jai Jute and Industries Limited. Now, the writ of summons bears the stamp of Gajmukh. You agree?
Yes.
Now, you have said that the defendant has changed its name to Gajmukh Binimay. That's who told you that?
Agarwal. Mr. Agarwal, one of the principal officer to whom I was acquainted in the office, and he disclosed.
Mr. Agrawal has informed me about the change of the name of the company, to whom I have met with him at the time of service of summons. Next.
It did not occur to you that when the company is not there, how can somebody sign on behalf of that company?
It is really it is a doubt, but as he put the written statement there for Jai Jute and Industrial Limited, I handed over to the writ of summons to him. It is the liability and responsibility of the person who put the written statement there, and he made me sure by putting the assured me putting the written statement that he is the representative of the old company.
Yes.
And now, Mr. Chakraborty, now look at the writ of summons a little upper up. You'll find that somebody has signed for Jai Jute and Industries Limited. Is it correct?
Sorry, sir.
Somebody signed for Jai Jute and Industries Limited.
Somebody.
We cannot read the name.
I cannot read it now. But
right. For Jai Jute is clear. For Jai Jute and Industries Limited.
And he signed there in my presence.
Fine. Very good. So for Jai Jute. And your case is Jai Jute has changed its name. Then how can he sign in that name?
He assured me. He assured me that he is the representative of the Jai Jute and Industrial Limited. Sorry, sir.
You are contradicting your own report. In the below, in your full report, you say that the person was security in charge of the present named company. That is Gajmukh. Then how could you accept him signing as Jai Jute and Industries?
Already he has signed. that I was handed over to the deed of summons.
So you are also doubtful to whom you have served.
No, I cannot say this. As he represented and he put his written statement there.
Yes. वो लाया नहीं है आया तो लगता नहीं आया ठीक है छोड़
May I ask him to come one day? Any day, I mean, learned friend, the urgency.
No, the other person is not, he has refused, so I am issuing warrant against him. The postal authority.
Lordship, if you have concluded with him.
No.
Lordship, my client is, your Lordship is out of his money, your Lordship, and he cannot bear these expenses, your Lordship. If it can be concluded,
then why he is fighting out? Allow us to file written statement, proceed with the suit.
I want only that this should be expedited, Lordship, and the next hearing, in case it is on the next hearing, it has to be concluded that day, your Lordship.
Correct.
Subject to
I wanted to conclude this, but the original is not here. Otherwise, I could continue till 1:30, no problem. This court is not having a problem to continue, but the original I have sent, but that is not traceable. In the meantime,
Regarding expedition, my lord, none of us can have any complaint in this court.
We cannot, Lordship. Your Lordship, the only problem is, your Lordship, it has to be concluded in the next hearing.
Correct, no problem.
And because, your Lordship, it is very
Will
clear.
examine the witness, he will examine.
Yes, Lordship, I will.
Yes, record. When you will able to come on the next time?
Sir, I am the employee of the learned district judge, and
if the order will be there, then you will be given granted leave to come here.
Are they paid any expenses? Are they paid any expenses as should be paid by the plaintiff?
Well, you are paid.
No, your Lordship, we have
Nobody has.
The government servant.
Government servant, yes.
They will get the TA.
I am the bailiff attached to the Nazaret department.
Nazaret department of your district judge. And whatever the summons is coming, going from this court, you are serving. And from coming what to Port Blair? Sorry, Port Blair. I am
My lord is from Port Blair.
You are coming from Barasat to Calcutta. Who is bearing the expenses?
Own cost.
But it is to be given by the party.
Your Lordship, both the parties, your Lordship, they are creating the issues. It is very clear. It is very clear, your Lordship. They are trying to defend.
It has changed the rules. Audience said rules.
What is the ticket charges?
Ticket charges, so.
My lord, at least 1,000 rupees should be given, my lord.
No, governments are why we have to see, yes.
Sir, ticket charges তো স্যার 20 টাকা আপ ডাউনের হচ্ছে টিকিট তারপরে এখান থেকে আবার মানে বনগাঁতে যেতে ওখান থেকে 20-40 টাকা আবার ওখানে নেয়
On the same day you can come and you can go.
হ্যাঁ স্যার
Need not to stay in Calcutta.
না নো স্যার
At least plus whole day fooding is also there, my lord.
Pay 1,000 rupees, 500, both the party pay that.
Lordship, oblige, your Lordship. Deeply obliged. Humanitarian ground.
Where do you deposit?
Next time he will come, yeah, you deposit to the registrar. And he, but
Getting
again
from register, my lord,
giving here
he'll pay another 10 days he has to come. So if you next day we pay,
come with the amount, on the next day it can be given. The seal bailiff is present. Full stop. Examination in chief, examination, the counsel for the defendant has examined the bailiff in part. But examination could not be completed. Accordingly, is deferred. Full stop. It is found that this court has also issued subpoena against what is the name? Against
Kanti. Doctor.
Manoj
Kanti Datto.
Pete Postman, posted at Noihati, Sub Post Office, Talpukur Road, Ward number 23. Full stop. The department has submitted the report. The subpoena has been served, has been sent to
29th.
Mr. Manoj Kanti Datto, but he has refused to accept the same. Full stop. In view of the above, let the warrant be issued against Mr. Manoj Kanti Datta. And the concern and the petition is directed to take and the petition is directed to take appropriate steps for submitting requisites for issuance of warrant against Manoj Kanti Datta. Full stop. Let him. कब होगा कोई 1 बजे कोई है 12:30 12:30 है 9 बजे फिर 1 कहाँ से होगा सब 12:30 नहीं है तो 1 कहाँ से होगा 3:45 एनी फ्राइडे एट 3 PM तो वो वहाँ में टाइम नहीं है दुनिया भर में
वो 3:30 हो जाए
10:30 पे टाइम लगेगा कोई नहीं और दूसरा अगस्त में कोई डेट नहीं है
Your Lordship, in 14th August, if it can be.
14th August you will available come on
Thursday.
2nd September on the holiday
2nd September.
on the working day
Your Lordship,
2nd
the matter
September
will again not get concluded before Puja holidays. Your
2nd
Lordship.
September is a working day
Your Lordship, any date in August, Your Lordship, 2nd August.
2nd August is working
Saturday.
sorry September 2nd August is working day
2nd August is a working day, Saturday.
Saturday
4th August. Lordship, 4th August, Your Lordship, 4th August. If it can be.
my diary couldn't
4th August or Your Lordship, 5th August.
कोई नहीं है कोई डेट नहीं है 10:30 नहीं रखेगा ना, तो सारा केस हो जाता 3:45 भी नहीं है ऐसा कैसे हो गया यार तुम कुछ खाली रखना बोल रहा
किसी दिन सैटरडे कोर्ट हो रहा है ना अभी किस दिन
कब है फर्स्ट डेट कब है फर्स्ट सितंबर कितना बजे 11:30
11:30.
फर्स्ट सितंबर
Obliged.
11:30
Deeply obliged, Your Lordship. 1st September. ठीक है जल्दी हो जाएगा खत्म करें इसको contempt
ये का रिकॉर्ड मंगा लेना
डीपली ऑब्लाइज्ड
obliged. भागो जल्दी
Yes.
Not me, it is. My lord, this.
Yes.
My lord, this is the matter where we are saying, my lord, seeking, my lord, some time.
When your witness will be available.
My lord,
Issues, framing, witness action.
yes, witness action, my lord.
It was
Wrongly recorded as framing of issues, but issues are, my lord, already.
Framed. Issues framed.
Yes, that's lordship will find 16th of July 2024 order record, my lord. My learned friend. Well, after 2 weeks, any date, my lord, subject to my lord's witness action, my lord, because the issues are already framed, my lord.
Though the matter is specially fixed today for witness action, but due to some personal difficulties, the plaintiff witness is not in position to appear before this court and plead for adjournment. In view of the above, case adjourned, let the matter appear on 15 September 3 p.m.
15 September at 2 p.m.
3 p.m.
Very grateful, my lord.
Yes. Next.
May it please your lordship. Beg to appear on behalf of the petitioner in this election petition.
Yes.
This pertains to the lastly concluded Lok Sabha elections in 2024 in respect of 18 Boshirhat parliamentary constituency. Now the petitioner has challenged the return
We
candidate.
have taken out an application.
I will hear you. I will hear you.
So the return candidate is the respondent number 1.
You give reply to both along.
So the election of the return candidate is under challenge. Now the primary point under which it is under challenge is the improper acceptance of the nomination form as filed by him on the 7th of May 2025 at 2024.
Respondent number 1.
Respondent number 1.
Yes.
Now, my lord, kindly take note of certain figures, my lord. The respondent number 1, being the return candidate, he secured 8,03,862 votes, whereas the petitioner, being set up by the Bharatiya Janata Party in respect of Boshirhat parliamentary constituency, came second by securing a total number of 4,70,215 votes.
Yes.
My lord, insofar as this particular constituency is concerned, the election was notified on the 7th of May 2024. My lord will find the election notification at page 374. But kindly take pain, my lord, to take page 374 of my lord's brief, my lord, judge's brief at page 370, volume 3. Yes. Marked as exhibit PD, exhibit G.
Yes.
My lord will find the date of the notification is, my lord, this is a gazette notification, 7th May 2024.
Yes.
And if thereafter, my lord, kindly turns overleaf and takes pen to come to page 381, my lord will find as against the third entry, that is serial number 18, Boshirhat was also notified.
On 1st of June.
Yes, but this is, yes, the date of election was 1st of June.
1st of June.
But the constituency number is, my lord, 18. 18 Boshirhat Lok Sabha constituency, my lord.
Correct.
But kindly mark the date of the notification, because date of the notification is, my lord, the relevant date. That is 7th of May 2024. Now, my lord, thereafter nomination was filed, the form 26, my lord. My lord knows that now, but previously there were, my lord, conflicts, my lord, insofar as filing of affidavits, no due certificates, etc. were concerned. Thereafter, the ECI, my lord, introduced statutory form 26. Now, statutory form 26, my lord, is, my lord, introduced pursuant to Rule 4A of the representation of people's of the conduct of election rules 1961. So it's a statutory form. Now in the statutory form, my lord, now everything was merged, and the no due certificate was also, my lord, accommodated in such statutory form. Now, my lord, the notification, pursuant to the notification, the nomination was submitted on the 7th of May 2024. My lord will find the form at page 382, my lord, of my lord's brief, my lord. Yes, it's a part of volume 3, my lord.
So this is the form he has submitted.
Yes, my lord. Form 26, my lord.
For conduct election.
Yes.
To conduct election.
Yes, my lord. My lord will find, my lord, form 26.
Yes.
Within bracket, my lord, see rule 4A.
Yes.
Now there, my lord will find, as again, yes, my lord, kindly takes page 392.
Yes.
This is with regard to the government dues, my lord, and the no objection certificate. It states that dues to departments dealing with government accommodation has the deponent been in occupation of accommodation provided by the government at any time during the last 10 years before the date of notification of the current election. My lord, kindly marks at any time during the last 10 years before the date of notification. That is 10 years preceding 7th of May 2024.
Has the deponent been in occupation of the accommodation provided by government at any time last standing before the date? Yes.
My lord. My lord, kindly mark, my lord, the period has to be reckoned, my lord, from 7th of May 2024. And if the answer to A above is yes, the following declaration may be furnished, namely the address of the government accommodation, and thereafter, my lord, the no due certificate as required, my lord, regarding rent, electricity charges, water charges, telephone charges, etc. Now, the return candidate conveniently marked not applicable, and as against the other no dues, my lord, in respect of the my lord, other items also, my lord, regarding which no dues were required to be submitted, he stated not applicable. He conveniently said that nil, it is not applicable in his case. Now, my lord, at the scrutiny, the petitioner had taken an objection. But she had brought on record the fact that while this, my lord, return candidate, while he was an MP, my lord, from Bosirhat Lok Sabha constituency during the period from 18th of May 2009 to 18th of May 2014, he was in fact using a government accommodation, the address being 180 South Avenue, New Delhi. Now, we had taken that objection, and in view of, my lord, the notification issued by the ECI, the ECI stated that this particular non-submission of no due certificate is a defect of substantial nature as contemplated in section 36 of the Representation of People's Act. So it's a fatal, my lord, it attracts a fatal consequence, my lord. Now, we had taken that particular point. Now, the returning officer, in hot haste, was initially reluctant, my lord, to even accept the objection. Mr. Das, my lord, assisting me, my lord, along with Mr. Bothra, my lord. Mr. Das was personally present there also. But thereafter, after much reluctance, finally, my lord, the objection was taken on record and it was rejected. My lord will find that particular order.
Where is the objection?
Yes. My lord, the order of the RO. Objection to follow.
397.
My lord, page 397, PD9.
Page 397.
My lord. Volume 4, my lord. Yes, my lord, may I place the affidavit, my lord, by which we had taken the objection. Page 397, objection against candidature of Sheikh Nurul Islam, candidate set up by All India Trinamool Congress from 18 Boshirat Lok Sabha constituency. I, Rekha Patra, wife of such and such, aged about such and such, by occupation such and such, solemnly swear and affirm as follows. The 15th Lok Sabha was dissolved on 18/5/2014. Copy of the excerpts from the statistical handbook is annexed as Annexure A. Sheikh Nurul Islam was the elected member of parliament from Boshirat Lok Sabha constituency. Copy of the MP information slip is available on website of the parliament of Sheikh Nurul Islam. And the photocopy of the relevant pages from the list of members of West Bengal Legislative Assembly published by the West Bengal Legislative Assembly Secretariat are enclosed and collectively marked as Annexure B. Admittedly, the present candidate set up by Trinamool Congress, Sheikh Nurul Islam, was allotted government accommodation during his stint as an MP in 15th Lok Sabha. The address of such government accommodation was 180 South Avenue, New Delhi 110011. Needless to state, the said accommodation is a government accommodation provided to members of parliament. In fact, Srimati Munmun Sen, ex-MP, while contesting the 2019 Lok Sabha elections from Asansol Lok Sabha constituency in her affidavit, acknowledged such fact. The entire affidavit of Munmun Sen and copy of the MP information slip as available from the website of the Parliament of Munmun Sen are enclosed. It is also stated that the said Nurul Islam was also using official telephone connection from the said governmental accommodation. Such numbers are evidence from Annexure B. Admittedly, the period reckoned from 18/5/2014 to 7/5/2014 is not beyond 10 years. Needless to state, the present elections to the Lok Sabha has been notified on 16/3/2024 by the ECI. In either cases, the period is not beyond 10 years, and as such, no due certificate under item number 8 in Form 26 was to be mandatorily furnished by the candidate. The candidate has neither furnished the requisite information at the relevant column and instead has made a false statement by stating that it is not applicable, nor has he filed the no due certificate from the concerned authorities with Form number 26 before the returning officer at the time of filing his nomination. It is reiterated that failure to submit to the returning officer no due certificate from the agencies concerned is a defect of substantial nature for the purpose of Section 36 of the Representation of People's Act 1951, and the cutoff date for submitting no due certificate was till 3 p.m. on the last date of filing nomination, that is 14/5/2024. As such, the nomination of Nurul Islam has to be mandatorily rejected under Section 36(2) of the RP Act 1951. Reliance is placed on the notification dated 6/3/2024 issued by the ECI, which is Annexure 2 and marked as Annexure D. We had also, this was shown. We had also annexed, apart from the documents, we had also relied upon the notification. The notification of the ECI, that is the March 2024 notification, will find 6 March. It has been exhibited, but it is also a part of this particular this objection. Will find it at page 462, the notification of the ECI, dated 6th of March 2024. Kindly takes pain to take page 468. Or may I just place it, my lord? Page 468, my lord. Serial number 13.
Yes.
Yes. Exhibit it's also there in the exhibit, my lord, volume 2, page 168. But my lord, referring to the exhibit, my lord, will cause less stress on my lord's optical nerves, because here, my lord, I find it's a little, my lord, smudged up, my lord. Here.
The exhibit?
This is exhibit C.
Okay.
Volume 2.
Okay.
Well, I'll just place the relevant portion, my lord. This is serial number 13. The Delhi High Court, in its order dated 7/8/2015 in WPC number 4912 of 98, had directed that every candidate at the time of filing nomination paper shall also file an additional affidavit along with the no due certificate issued from the agencies providing electricity, water, telephone, and accommodation in case he or she had been in accommodation of any government accommodation during the last 10 years. Failure to file the additional affidavit along with no due certificate would be treated as a defect of substantial nature for the purpose of Section 36 of the Representation of People's Act 1951. Now, my lord, if we read it, my lord, harmoniously with the provisions of my lord, Section 36, my lord, this speaks about, my lord, the scrutiny of the nomination papers. Well, the exercise has been outlined. The exercise, my lord, which has to be, my lord, done by the my lord, undergone by the returning officer. Now, subsection 4 of Section 36, my lord, states that the returning officer shall not reject any nomination paper on the ground of any defect which is not of a substantial character. So, therefore, indicating, my lord, that all substantial defects in the nomination paper deserves, my lord, an outright rejection.
Yes.
Now, here, despite, my lord, our objection being raised by way of an affidavit, the RO at page 474, my lord, volume 474, this is volume 4, my lord, 474, the RO, acting arbitrarily and, my lord, as a product of mechanical action, my lord, the objection.
This is the order of RO.
My lord, this is 15/5/2024. But I'll just place the order. Whereas with a notification number 7/5/2024, ECI issued the notice.
Yes.
Yes. And thereafter, my lord, whereas up to the last day of making nomination on 14/5/24, total 15 number of candidates have filed nomination papers. And whereas today on 15/5/24, scrutiny of nomination papers of 15 number of candidates has been taken up as per provision of Section 36 of the Representation of People's Act. Whereas Miraj Mullah, son of Janab Mullah, residing at village such and such, and Rekha Patro, my lord, the petitioner herein, wife of such and such, residing at such and such, raised an objection against Sheikh Nurul Islam, being the returned candidate, nominated candidate set up by All India Trinamool Congress for non-submission of no due certificate under point number 82 in affidavit form 26, dated 7/5/2024. The objection has been duly noted and examined. Whereas the affidavit submitted by Nurul Islam was filed in correct format and no column was left blank, the said affidavit was displayed on notice board of the RO and was uploaded over public domain as prescribed for wide publicity. As per provision, anyone may file counter affidavit against the statement noted in the affidavit filed by the candidate before the returning officer. No such counter affidavit was filed before the returning officer, 18 Boshirat PC. Till the commencement of the scrutiny, the affidavit has been found to be valid by the returning officer. Therefore, the objection raised at the time of scrutiny is considered and disposed of. With this order, the proceedings of scrutiny of nomination papers in respect of all 15 number of candidates for the such and such is completed and disposed of. So, my lord, this was the order, my lord, which was passed. Now, by way of the election petition, my lord, we have also, my lord, challenged this particular order because I say, my lord, that this has resulted into, my lord, illegal and improper acceptance of the nomination paper despite of the return candidate, despite there being admittedly a defect of substantial nature. No.
So what he is telling, no such counter affidavit filed before the returning.
Yes, we had filed an affidavit, my lord. And my lord, there are judgments also galore to demonstrate that, my lord, the returning officer discharges quasi-judicial functions. Though the returning officer is not a court, she cannot take evidence or hold trials. But the summary procedure contemplates of, my lord, supplying of information. She can do it suo motu, she can do it at the complaint of any party. And, my lord, within the four corners of, my lord, this particular act also, my lord, but this counter affidavit, my lord, but this seems completely alien. This was, my lord, just
So
done, my lord, for
the only reason he has
Yes.
rejected your objection.
Yes.
No counter affidavit was filed
Yes.
before the returning
Yes,
officer.
our case was on the basis
What
of
is the procedure for filing the objection before
my lord, the there is no such procedure, my lord. We have to, my lord. Just a second, please, sir. My lord, kindly take section 36, my lord. Kindly takes page 36.
Which section?
I'm sorry, my lord, section 36, my lord. It states, yes. Yes. But kindly takes subsection 5 of section 36. The returning officer shall hold the scrutiny on the date appointed in this behalf under clause B of section 30 and shall not allow any adjournment of proceedings except when such proceedings are interrupted or obstructed by riot, open violence or causes beyond his control. Now, thereafter, my lord, the proviso, provided that in case an objection is raised by the returning officer or is made by any other person.
Where from your?
My lord, the proviso, my lord.
Yes, proviso in case of objection.
Yes. That in case an objection is raised by the returning officer or is made by any other person. Here, my lord, it was made by any other person. The candidate concerned may be allowed time to rebut it, not later than the next day, but one following the date fixed for scrutiny. And the returning officer shall record his decision on the date to which the proceedings have been adjourned. So this is the only procedure, my lord, which is contemplated, my lord.
Yes.
Barring this, my lord, it does not speak of any, my lord, counter affidavit, etc. We had, my lord, by way of and my lord, even if, my lord, we go by the, my lord, the language of the order passed by the returning officer, we had, my lord, in fact, taken the objection by way of an affidavit, my lord, sworn before the notary public. So it is, my lord, a counter affidavit.
But you have stated with regard to his non-use. You have given the affidavit. Where is the document?
Yes, now, my lord, I will be placing the documents, my lord.
The document.
Yes.
Along with the he has enjoyed this government accommodation.
Yes. And the law also says, my lord, that orders passed in summary proceedings, my lord, has to be challenged by way of, my lord, filing the election petition. So, my lord, kindly, yes, my lord, kindly takes page 173, এটা কোথায় আছে 73? My lord, volume 2. এই যে আমার কাছে আছে।
এখান থেকে স্টার্ট হচ্ছে BSc design of every sheet.
Yes. But kindly takes page 173 and 174, my lord. We had made an application under section 6 of the Right to Information Act, my lord.
Yes.
Now, these are the informations, my lord, which are supplied. Who was the member? Page 174, my lord. Who was the member of parliament from 18 Boshirhat Parliamentary Lok Sabha constituency in 15th Lok Sabha? What was the date on which the member of parliament from 18th Boshirhat Parliament constituency assumed office in the 15th Lok Sabha and the date on which such member of parliament debited such office? Now, the response from the secretariat, the Lok Sabha secretariat is, my lord, late Sri Sheikh Nurul Islam was the member of 15th Lok Sabha from 18/5/2009 to 18/5/2014. My lord, kindly marks this, my lord. Representing the Boshirhat parliamentary constituency of West Bengal. The second response, the response to my my third query is, what was the date on which the 15th Lok Sabha was dissolved? The response is that the 15th Lok Sabha was dissolved on 18th of May 2014. And thereafter, my lord, regarding the government accommodation we had asked for. So they said that the concerned branch, that is the MS, has stated that as per procedure, file has been weeded out. So, my lord, thereafter, the next page, my lord, that I'll be relying upon is, my lord, my lord, the handbook.
The next page.
Yes, which starts from page 175. My lord, kindly, my lord, takes note, my lord. This is the handbook of members of the West Bengal Legislative Assembly, together with the list of ministers and ministers of state of government of West Bengal and members of the House of People Lok Sabha,
yes,
representing West Bengal.
Yes.
No, my lord, I have annexed the entire handbook. Page 327, my lord, will find volume 3. Page 327.
327.
My lord, volume 3. My lord.
Yes.
But it kindly takes my lord at the top 18 Boshirhat, Sri Sheikh Nurul Islam, AITC, that is All India Trinamool Congress. Thereafter his residential address, and thereafter my lord his office accommodation, that is 180 South Avenue, New Delhi, 110011, and my lord his mobile number, and also my lord his landline number at the official residence, my lord. That is 01123795185.
Yes. Yes.
My lord.
327.
Telling, my lord.
Not tally.
Because 327 at the top, it starts with Sri Subroto Mukherjee, Minister in charge.
In any event, they have filed an application. They will be addressing only on that aspect.
Please check.
I will. Please find it out. Help Koro. But before that, my lord, kindly takes my lord page 323. Oh, my learned friend was looking at the affidavit. My lord. You have to look at the judge's brief. My lord.
Yes, 323.
323, my lord will find, my lord, the compartments, my lord. First is serial number, then name of constituency, then name, then party group affiliation, then permanent address and telephone number, and thereafter Delhi address and telephone number.
Yes.
So against Delhi address and telephone number, my lord will find 180 South Avenue. That is against column number 6. Thereafter, my lord may kindly take pain to take page 358. Same volume, my lord. Now, this is the Form 26 affidavit, my lord, affirmed by one Srimati Munmun Sen. She was a very reputed, my lord, actress, my lord, in the film industry, in Bengali film industry. A daughter of a legend also, my lord, the legendary Suchitra Sen.
Yes.
So, she was elected, and she thereafter, my lord, she had, my lord, submitted this affidavit. কোথায় আছে page?
369.
My lord, kindly takes page 369 of this affidavit. Yes. Yes. My lord, may kindly see, my lord, government dues, the column. Dues to department dealing with government accommodation. Has the deponent been in occupation of accommodation provided by the government at any time during the last 10 years before the date of notification of the current election?
Yes.
She states yes. If answer to A above is yes, the following declaration may be furnished, namely, the address of the government accommodation. My lord, kindly marks it. It is 180 South Avenue, New Delhi, 110011.
Yes.
Well, this is basically an open and shut case, my lord, on the basis of, my lord, public documents also. So we had taken, my lord, these particular objections also, my lord, apart from, my lord, the RTI response, because the RTI response was subsequent to, my lord, passing of this order, because, my lord, this was, my lord, during it. This was at the time of filing of the election petition, my lord. So, my lord, this is a clear-cut case, my lord, where there cannot be any hesitation that the nomination form of the returned candidate was illegally and improperly accepted, my lord, which constitutes a ground for declaring the election of the returned candidate void, my lord. My lord will find it at section 100, subsection 1D, Roman 1 of the Representation of People's Act. I'll just place it, my lord, for my lord. It speaks about page 70, my lord will find of that book. Same edition, though.
Yes, yes.
Grounds for declaring election to be void. subject to the provisions of subsection 2, if the High Court is of the opinion that, but it kindly takes my lord D now, the result of election in so far as it concerns a returned candidate has been materially affected. Now thereafter Roman 2, I'm sorry, my lord, Roman 1, yes, Roman 1, by improper acceptance of any nomination. The High Court shall declare the election of the returned candidate to be void.
Yes.
No, for my satisfaction, my lord, I'll also, my lord, just place, my lord, refer to, my lord, section 84, my lord, of the Representation of People's Act, depicting, my lord, the statutory assurance, my lord, petitioner has, my lord, insofar as claiming of relief is concerned. A petitioner may, in addition to claiming a declaration that the election of all or any of the returned candidates is void, claim a further declaration that he himself or any other candidate has been duly elected. So that is exactly my prayer, my lord, also in this particular case.
A petitioner may, in addition to claiming the declaration that the election of all or any of the written candidates void, claim a further declaration that he himself or any other candidate has been duly elected.
Yes, well, that is exactly, my lord. My prayers are absolutely commensurate, my lord, with the language of section 84, my lord.
What is your prayer?
My prayer is, my lord,
Declaration written candidate, petitioner written candidate. Petitioner is the written candidate.
Page 13 of the election petition.
Yes.
Declaration that the election of the returned candidate, that is respondent number 1, from 18 Boshirhat Lok Sabha constituency be declared void and set aside. Then B is declaration that the petitioner is the returned candidate from 18 Boshirhat parliamentary constituency in the House of People, and thereafter decree being passed setting aside the order dated 15/5/2024. That is the returning officer's order, and thereafter there were interim reliefs also, which in fact we never pressed for, my lord. So,
so A and B,
my lord, A and B, my lord. But I say that in, my lord, while having regard to the fact that, my lord, on the day when the nomination paper was filed, or when the election was also notified, that is 7th of May, the petitioner had, my lord, not the petitioner, the respondent number 1, my lord, committed a fundamental error, my lord, rendering defect of a substantial nature by misdeclaring that he has not been in occupation of any government accommodation during the last 10 years before the date of notification of the current election. But I, insofar as, my lord, the meaning of, my lord, year is concerned, my lord, but I am carrying the law lexicon also. The law lexicon bar kore do. That was back kora ache. I flagged it. Yes. But I'll just read it out and hand it over to your lordship. I could not place it inside the, my lord, the photocopying machine. So, my lord, here is, my lord, year.
From which date to which date?
A cycle in the Gregorian calendar having, this date is, my lord, 7th May 2014 to 7th May 2024.
7th May.
And the Lok Sabha was dissolved on 18th of May
7th May 2014 to
7th of May 2024.
2024.
And the Lok Sabha was dissolved, as I had indicated, my lord, from the 18th of May 2014. Now, my lord, here, my lord, as stated in the law lexicon, is a cycle in the Gregorian calendar having 365 or 366 days divided into 12 months, beginning with January and ending with December, a period of 12 months. So, my lord, I will just, my lord.
Okay, I will take note.
Very good, my lord.
Law lexicon to?
This is law lexicon. But this is by Ramanatha Iyer. So, my lord, these are the short facts, my lord, insofar as this particular case is concerned. I'll just repeat, my lord, I'll just sum up. First is, my lord, non-submission of no due certificate is a defect of substantial nature by virtue of, my lord, the Election Commission of India's notification dated 6th of March 2024, read with section 36, subsection 4 of the Representation of People's Act. There was objection also, my lord, taken in terms of the proviso to section 36, subsection 5.
Yes.
Yes, yes, Dekabo.
Yes, there is there.
Yes, and
But only one question. Okay, 180 South Avenue,
my lord,
327.
my lord.
With regard to that, RTI has not been provided.
No, RTI has not been provided because it has been weeded out, they say. Yes.
Correct. And 180, where from you can correlate from which date to
My lord, from 180, my lord, I can code. This was the allotted, my lord, as I had indicated.
That's why.
This was the allotted official Delhi accommodation.
Correct.
And my lord, in fact, thereafter, my lord, the other candidate, my lord, whose affidavit I have referred to, my lord, page 300 and
that is Munmun Sen.
Munmun Sen. She also admits in her affidavit filed before, my lord, the Election Commission of India.
That's prior to that.
No, that is subsequent to that.
Subsequent to
Yes,
that.
that is subsequent to that.
Subsequent to that. But now we have to judge with regard to this case.
My lord.
Admittedly, he has not mentioned with regard to he occupied the government accommodation, and a specific time period is given. Admittedly, he was elected. This was allotted.
My lord.
This was allotted. Whether he has occupied, one thing. Second thing, whether he is in occupation of the premises in question and from which period to which period.
My lord, what I say, my lord, in my humble understanding, my lord. But since the provisions of, my lord, the CPC are not strict to sensu applicable, but, my lord, the principles are applicable, my lord. That is what our rules also say, my lord. So here, my lord, but we have to adopt, my lord, the principles of preponderance of probability instead of, my lord, establishing it beyond reasonable doubt. But I say, my lord, that this particular fact, my lord, the factum.
But we have also to see the infringement of the right of the person.
Yes, absolutely, my lord. The factum that he had held it till the 18th of May 2014 is evidence from, my lord, the affidavit filed by the subsequent candidate, the subsequent allottee, because it was only upon Munmun Sen being elected from 2014 to 2019, but she came into, my lord, possession of this particular, my lord, government accommodation. Because unless and until, my lord, Munmun Sen was elected, my lord,
she could not.
She could not have, my lord.
Correct.
She could not have.
Correct.
And, my lord, the fact that this person, my lord, the respondent number 1, was in occupation, but that is evidence, my lord, from the handbook, my lord, that I have just placed. From the, my lord,
That's
page
327.
327.
327, that's correct. It was allotted.
It's not allotted, it is the address. Delhi address and telephone number.
Address.
Yes, he had a telephone number also. This is published by the West Bengal Legislative Assembly. Right? This particular handbook is published by the West Bengal Legislative Assembly.
Okay.
And, my lord, another fact, my lord, that the candidate has to furnish information only under the Act and the rules, my lord, and not beyond. 33 capital B, my lord, of the Representation of People's Act, my lord. My lord, mandates, my lord, such exercise, my lord, upon the candidate. It has an overriding effect also. It states that notwithstanding anything contained in any judgment, degree or order of any court or any direction, order or any other instruction issued by the ECI, no candidate shall be liable to disclose or furnish any such information in respect of his election, which is not required to be disclosed or furnished under this Act or the rules made thereunder. Now, that is why, my lord, I commence my arguments by referring to Form 26 and by stating, my lord, that Form 26, my lord, is, my lord, a statutory form in terms of Rule 4A, my lord.
Correct.
So he was bound, my lord, to furnish this particular information. Candidate, my lord, who was set up by the Bharatiya Janata Party, from Birbhum Lok Sabha constituency. Now, his nomination, my lord, was rejected also, my lord, on the ground of, my lord, non-submission of no due certificate. My lord, during the same election, my lord, that is the 2024 election, my lord, we have, my lord, got a copy of that order, my lord, page 476, my lord. So this, my lord, depicts the strictness with which, my lord, this particular clause, my lord, in Form 26, my lord, is seen. So this gentleman, my lord, was an IPS officer. He tendered his resignation, submitted his nomination, and thereafter, my lord, it got rejected, owing to, my lord, non-submission of no due certificate. Then I say, my lord, that the returning officer also, while exercising quasi-judicial functions,
Yes.
has acted, my lord, arbitrary and, my lord, mechanically.
What is the reply? They have filed the affidavit.
No, but
Returning officer, they have filed reply.
the RO has filed, yes. The RO has filed.
What stand they have taken?
RO
They have
stand.
taken the stance that they could not have gone into the.
Now, reply to them. But the RO seems to have, my lord,
Reiterated the stance of.
reiterated, my lord, the stance, my lord, taken by the return candidate. My lord will find she has annexed the affidavit filed by the return candidate against, my lord, para 4, subparagraph C. Thereafter, my lord, she has referred to an instruction dated 6/3/2024 that no dues are required to be furnished only by those candidates who have been in occupation of accommodation provided by the government at any time during the last 10 years before the date of notification of the current election. And thereafter, clause E, candidate Sheikh Nurul Islam in his affidavit has declared he has not been in occupation of accommodation provided by the government.
Where from your reading?
My lord, this is page 12, my lord, subpara E of paragraph 4.
Candidate Nurul Islam.
In his affidavit has declared that he has not been in occupation of accommodation provided by the government at any time during the last 10 years before the date of notification. Therefore, there does not arise a question of applicability of submission of no due certificate as per information made available to the returning officer in form of affidavit of candidate Nurul Islam. The deponent has declared the submission of no due certificate by him is not applicable to him as he has not been in occupation of accommodation provided by the government at any time during the last 10 years before the date of notification of the current election. So this is, my lord, completely a complete digression, my lord.
In your application,
my lord,
when you are where you are dealt with the your affidavit, your objection in affidavit,
my
in
lord,
which paragraph you are dealt with?
yes, আমার EP-তে বলো।
And in which paragraph you dealt with the handbook of the person with regard to the allotment of the quarter
I'll tell you, lordship.
residential house? And what is the objection they have raised on that?
My lord. My lord, page 9, paragraph 12, my lord,
Of your application?
of my election petition. But there is something, my lord, more to indicate, my lord, from the affidavit of the returning officer. Now, my lord, as I had placed the order passed by the returning officer, the order was non-filing of counter affidavit. Now, here, my lord, clearly, my lord, violating the principles as laid down in Mohinder Singhal's case also, my lord. She is now trying to supply further reasons, my lord. And by, my lord, she is now referring to completely different reasons. She says that despite the objection filed by the candidates, I could not have taken cognizance of the objection, page 13, subpara G, my lord, kindly takes. The moot question is applicability of submission of no due certificate which does not arise by virtue of the candidate declaring that he had not been in occupation of accommodation provided by the government at any time during the last 10 years before the date of notification. So this is a complete turnaround, my lord, from what, my lord, were the findings in her order.
Mute question is applicability of submission no due certificate which does not arise by virtue of the candidate declaring that he has not. So, what is the duty of the returning officer?
That is exactly my lord, what is troubling us, my lord, what prompted us, my lord. Thereafter, she says, where submission of no due certificate is not applicable as declared by in the affidavit by the candidate, the question of failure to provide no due certificate does not arise. Therefore, there was no defect of substantial character found. Well, this, my lord, I say, is, my lord, somehow taking, or if my lord kindly takes judicial notice of the fact, my lord, that since inception of this particular case, the mode and manner, my lord, in which, my lord, the returning officer had conducted herself, firstly, my lord, by way of filing, my lord, a statement of fact, and thereafter, my lord, subject, after the admonition, my lord, of the honorable court, my lord, resigning from that stand, then the, my lord, the state government, my lord, taking interest, appearing, trying to file, my lord, affidavits. So it has continued, my lord, since that particular date only, my lord. It has continued from the very date of passing of the order.
Yes.
So, my lord, I say, my lord, that she has also failed in discharge of her quasi-judicial duty. She has acted arbitrarily, mechanically, my lord, and with a closed mind to favor the return candidate by accepting illegally her nomination, my lord. But in this connection, my lord, I'll just be referring to, my lord, only one judgment, my lord, that... oh, handbook, yes, yes.
Election petition paragraph 6 refer করেছো MP information slip.
My lord, para 6 of the election petition, we have referred to, my lord, the MP information slip, my lord. Paragraph number 6, my lord, of the election petition.
Yes.
Paragraph 7.
And, my lord, regarding the handbook, my lord, there was, my lord's query was, my lord, where have we referred to it, my lord? Paragraph 7.
Yes.
So, my lord, in view of, my lord, the facts of the case and, my lord, the law applicable thereto, my lord, having regard to, my lord, the various provisions of the Representation of People's Act, and, my lord, I'll cite just one judgment, my lord, for my satisfaction. It's reported in 1999, volume 2, Supreme Court cases, page 489. It just states that the returning officer discharges a quasi-judicial function, my lord, and it has to be non-arbitrary and there has to be applicability of the principles of natural justice. This is the para. Yes. Kindly takes Thou Joshep ke? What is it? Yes. Paragraph 20.
Yes.
Through the proviso, the legislature refers to, my lord, the proviso as contained in section 36, subsection 5, my lord, that I had placed already. Through the proviso, the legislature has provided that in case an objection is raised during the scrutiny to the validity of a nomination paper of a candidate, the returning officer may give an opportunity to the candidate concerned to rebut the objection by giving him not later than the next day. This is in accord with the principles of natural justice also. So, my lord, natural justice applies, my lord, in each and every stage, my lord. And here also, my lord, yes. But thereafter, my lord, kindly takes, this is in accord with the principles of natural justice also, since no other candidate had raised any objection to the claim of the respondent of being the official candidate of BJP, and the objection had been raised by the returning officer suo motu, the mandate of the proviso to section 36(5) of the Act warranted holding of a summary inquiry to determine the validity of the nomination paper by the returning officer while exercising his quasi-judicial function, my lord. So I say, my lord, the returning officer has, my lord, sided with the, my lord, return candidate and has failed miserably in discharging her duties, my lord, for my lord, benefiting, my lord, the return candidate or to contest the elections despite on the face of it, my lord, being, my lord, ineligible otherwise, my lord. So, my lord, these are my humble submissions, my lord, and I humbly, my lord, beseech your lordship, my lord, that in light of the facts of the instant case and having regard to the law applicable thereto, my lord, the my lord, election, just a second, the election of the return candidate, my lord, be declared void, and my lord, prayer C, my lord, the prayer B, my lord, the other prayer, my lord, I being the, my lord, I having secured, my lord, most of the votes, my lord, be declared, my lord, as the winning candidate, my lord. And these are my submissions, my lord, insofar as, my lord, the election petition is concerned. And if, my lord, permits me, my lord, I am ready to, my lord, even, my lord, submit with regard to their application. Very well, let them submit.
Why they want to
Yes. The election petition. But I understand my learned friend will not be submitting insofar as the election petition is
He
concerned.
wanted to delete the name.
Yes, exactly.
Lord, I referred to, I shall
May I
be,
seek, my lord, 2 minutes sleep, my lord.
I have taken out GA1 of 2025. I am the returning officer.
Yes.
But this is an application seeking, my lord, my deletion from the array of respondents. My lord, I shall be referring to 5 decisions, my lord, one by one. First is 1982 1 SCC 691.
1982.
1 SCC 691. This is Jyoti Basu versus Devi Ghoshal. Please consider paragraphs 3 and 13. Three starts from page 693 bottom. To properly appreciate the rival contentions, it is necessary to refer to the relevant provisions of the Constitution and the two Representation of People's Act of 1950 and 51.
Yes.
My lord, thereafter, the various provisions are extracted and are quoted. My lord, if my lord kindly takes up paragraph 13. In paragraph 6, my lord, section 82 is quoted and extracted. Paragraph 6 is at page 694, bottom.
Yes.
My lord, my claim in my application is by reason of 82 and 86, I am not at all a necessary party. Lordship will kindly turn to paragraph 13. At page 700. My lord, I need not take through the discussions. In view of the foregoing discussions, we are of the opinion that no one may be joined as a party to an election petition otherwise than as provided by sections 82 and 86(4) of the Act. It follows that a person who is not a candidate may not be joined as a respondent to the election petition. The appeal is therefore allowed with costs so and so. My lord, this is para 13. I next refer to and rely upon 1991 Supplementary to SCC 624. Straight away, my lord, comes to paragraph 4. Paragraph 4 is at page 625.
Yes.
Learned counsel for the petitioner urged that even if the Election Commission was not a necessary party, it was a proper party since its orders have been challenged in the election petition. He further urged that since Civil Procedure Code 1908 is applicable to trial of an election petition, the concept of proper party is applicable to the trial of election petition. We find no merit in the contention. Section 87 of the Act lays down that the subject to the provisions of the Act and any rules made thereunder, every election petition shall be tried by the High Court as nearly as may be, in accordance with the procedure applicable under Code of Civil Procedure 1908 to the trial of suits. Provisions of the Civil Procedure Code have thus been made applicable to the trial of an election petition to the limited extent as would appear from the expression subject to the provisions of this Act. Since Section 82 designates the persons who are to be joined as respondents to the petition, provisions of Civil Procedure Code 1908 relating to the joinder of parties stands excluded. Under the code, even if a party is not a necessary party, he is required to be joined as a party to a suit or proceedings if such person is a proper party. But the Representation of People Act 1951 does not provide for joinder of a proper party to an election petition. The concept of joining a proper party to an election petition is ruled out by the provisions of the Act. The concept of joinder of a proper party to a suit or proceeding underlying Order 1 of the Civil Procedure Code cannot be imported to the trial of election petitions in view of the express provisions of Sections 82 and 87 of the Act. The Act is a self-contained code which does not contemplate joinder of a person or authority to an election petition on the ground of proper party. In K. Venkateshwara Rao versus Bekkam Narasimha Reddy, this court, while discussing the application of Order 1 Rule 10 of the Civil Procedure Code to an election petition, held that there could not be any addition of parties in the case of an election petition except under the provisions of subsection 4 of Section 86 of the Act. Again, in Jyoti Basu versus Devi Ghoshal, this court held that the concept of proper party is and must remain alien to an election dispute under the Representation of People's Act 1951. Only those may be joined as respondents to an election petition who are mentioned in Section 82 and Section 86(4), and no others. However desirable and expedient it may appear to be, none else shall be joined as respondents. My Lord, the third decision I refer to and rely upon is 2002-3 Supreme Court cases 521.
Yes.
Please turn to page 523, paragraph 1. I'll just read the first paragraph. This appeal is directed against an order dated 16/6/2000, passed in election petition number 29 of 1999. The aforesaid election petition has been filed by the appellant, challenging the validity of the election to the House of People from Bangalore North Parliamentary Constituency, in which election Respondent 1 was declared to have been elected. In the election petition, the election commissioner, the returning officer, and the Chief Electoral Officer of the state of Karnataka had been arrayed as the respondents 6, 7, and 8. Those respondents filed an application before the High Court of Karnataka for their deletion inter alia on the ground that under Section 82 of the Representation of People's Act, it has been clearly indicated that who should be the parties to an election petition, and since they have been unnecessarily impleaded, they should be deleted. The High Court, by the impugned judgment, having deleted the said respondents 6, 7, and 8 from the array of parties, the present appeal has been preferred. My Lord then kindly takes up page 526. Page 526, at the bottom, 3 lines from the bottom. The sentence starts with, there is no dispute. Lordship has that. There is no dispute with the proposition. This is the finding of the court. Yes. There is no dispute with the proposition that a free and fair electoral process is the foundation of our democracy. But the question for consideration is whether by indicating in the act as to who shall be arrayed as party, the court would be justified in allowing some others as parties to an election petition. For the aforesaid proposition, Gill case is no authority. Mr. Venkatramani then relied upon the decision of the Calcutta High Court in Dijendralal Chengupto versus Hare Krishna Konar, where the question came up for consideration directly, and the Calcutta High Court did observe that the returning officer may nevertheless, in an appropriate case, be proper party, who may be added to the election petition, and undoubtedly the aforesaid observation supports the contention of Mr. Venkatramani.
Following the aforesaid decision, a learned single judge of the Bombay High Court in the case of H.R. Gokhale versus Bharucha Noshir had also observed the observations of Shah Judge in Ram Sevak Yadav's case in paragraph 6 are not intended to lay down that the returning officer can in no event be a proper party to an election petition. But both the aforesaid decisions of Calcutta High Court and Bombay High Court had been considered by this court in Jyoti Basu's case, and the court took the view that the public policy and legislative wisdom both seem to point to an interpretation of the provisions of the Representation of People's Act, which does not permit the joining as parties of persons other than those mentioned in sections 82 and 86(4). The court also in paragraph 12 considered the consequences if persons other than those mentioned in section 82 are permitted to be added as parties, and held that the necessary consequences would be an unending, disorderly election dispute with no hope of achieving the goal contemplated by section 86(6) of the Act. In the aforesaid premises, we reiterate the views taken by this court in Jyoti Basu's case and reaffirmed in the later case of B. Sundara Rami Reddy, and we saw no infirmity with the impugned judgment requiring our interference under Article 136 of the Constitution. The appeal accordingly fails and is dismissed. My Lord, all these three are taken into consideration by our High Court, which is AIR 2002 Cal 261. This corresponds with 2002 SCC Online Cal 458. Please take up paragraph 5 first, my lord. Lordship has got it, my lord. Paragraph 5, it starts with respondent number 6.
Yes.
Respondent number 6. Mobaswar Ali Boiddo, being the returning officer, has contested the election petition by filing the written statement, alleging inter alia that the said election petition is not maintainable in its present form and in the eye of law, and that the same is not maintainable for misjoinder of parties. As per the case of respondent number 6, by memo bearing so-and-so, issued by him, all contesting candidates were informed that setting of ballot papers in electronic voting machines and sealing thereon would be held at so-and-so Polytechnic Shivayatan, Jhargram from May 3rd, 2001 to May 6, 2001. And it was further mentioned that the said program would start at 10:30 a.m. and continued up to 5 p.m. each day, and a candidate, his election agent, and not more than 2 representatives authorized by the candidate would be allowed to remain present at such time in the above mentioned venue. Now, straight away comes to paragraph 6. My lord, I skipped the rest of the paragraph 5, which is not relevant. 6. On perusal of the pleadings of the parties and the documents, the following issues have been framed for the purpose of trial of the instant election petition. Comes to 2. Is the returning officer a necessary party in this suit? Then, my lord, paragraph 8. Mr. Devashish Kaur-Gupta, the learned advocate for the respondent number 6, has assailed maintainability of the instant election petition because of misjoinder of parties. He has argued that the respondent number 6, Mr. Boiddo, who was the returning officer, cannot be made party to the election petition since the relevant provisions of the Representation of People Act do not permit joining of persons as parties other than those mentioned in section 82 and section 86(4) of the Act. Then, my lord, section 82 is extracted. Comes to paragraph 10. Mr. Kaur-Gupta has contended that the returning officer, who is the respondent number 6, cannot come within the category of persons referred to in section 82 and section 86(4) of the Act, and so he cannot be made party to the election petition. He has cited Jyoti Basu and Michael B. Fernandez versus C.K. Jafar Sharif, AIR 2002, Supreme Court 1041. Then, my lord, straight away comes to paragraph 15. Lordship has got it, my lord.
Yes.
On hearing the rival contentions raised by Mr. Kaur and Mr. Rai Choudhury and considering the materials on record, I am clearly of the view that the principles of law enunciated by the Supreme Court in the above noted decisions cited by Mr. Kaur apply with full force to the case in hand. It is manifestly clear that the provisions under the Act do not permit joining of persons as parties to the election petition other than those mentioned in section 82 and 86(4) of the Act. And since the returning officer, who is the respondent number 6, does not come within the ambit of section 82 and 86(4) of the Act, he cannot be made party to the instant election petition, which evidently suffers from the defect of misjoinder of respondent number 6 as party thereto. Then, my lord, paragraph 16. Paragraph 16 from what is noteworthy. Now, the question that crops up for consideration is whether or not the instant election petition as a whole is maintainable because of misjoinder of the respondent number 6 as a party thereto. Relying on the decision of the Supreme Court in Mohan Raj, Mr. Kaur has argued that since the special provisions as to addition of party to the election petition have been laid down in the Act itself, the court cannot use Order 6 Rule 17 or Order 1 Rule 10 of the Code of Civil Procedure to avoid any consequence because of non-jointer or misjointer of party to the election petition. And for that reason, the present election petition as a whole is not maintainable because of misjoinder of respondent number 6 as a party to the election petition. Considering the points in controversy raised by Mr. Kaur and Mr. Rai Choudhury with regard to maintainability of the election petition, carefully and judging the matter in the light of the principles of law enunciated by the Supreme Court in the above noted decisions cited by Mr. Kaur, I am of the view that had it been the case of non-joinder of necessary party to the election petition as a whole would be not maintainable. The decision in Mohan Raj relates to non-joinder of a party which had no curative means to save the petition, but the same does not apply in case of misjoinder of party. Since the present matter relates to misjoinder of the returning officer, being the respondent number 6 as party to the election petition, such defect cannot entail dismissal of the election petition as a whole, being not maintainable. It is noteworthy in this context that in the case of Jyoti Basu, the names of the appellants and the 7th respondent in the appeal were directed to be struck out from the array of parties in the election petition. Likewise, in Michael B. Fernandez, as already referred to, the Supreme Court did not interfere with the order of the High Court deleting the party respondents, the election commissioner, the returning officer, and the chief electoral officer from the array of parties. For the reasons as aforesaid, I am of the view that the respondent number 6, being the returning officer, cannot be made party to the instant election petition in view of the provisions of the Act, as noted above, and for that reason, his name is directed to be struck out from the array of parties in the instant election petition. The election petition suffers from the obvious defect of misjoinder of party, but the same as a whole cannot be said to be not maintainable because of such defect. Both issue numbers 1 and 2 are thus disposed of. The last decision which I cite is of 2025. My lord, this is 2025 SCC Online Bombay 8.
But this could appreciate your submission. You have not stopped only with the benefit of your contents. I appreciate your submission.
No.
No, with regard to otherwise.
I was studying, my lord. This is not to be dismissed.
That's why
Yes.
I appreciate that.
Only my deletion.
He's also making submissions for me. Even I am armed with this judgment.
এটা কোনটা প্যারাগ্রাফস?
আমি তোমার কন্টেনশনটাকে তো আমি অ্যাডপ্ট করব। ছেড়ে দাও।
Yes.
Please take up, my lord, paragraph 3. Paragraph 3 is at the second page. Unfortunately, these online prints they don't have successive pages. Application L number 22668 of 2021 is filed by respondents 1, 2, and 3, addressed Election Commission for the following reliefs. My lord, the prayers are set out. In effect, respondents 1, 2, and 3 seek deletion of their names from the election petition filed by the petitioner. When the present election petition and aforesaid applications are heard, none is present for the respondents 1, 2, and 3 in the petition. The grounds on which the aforementioned application is filed by the respondents 1, 2, and 3 are contained in paras 4 to 8 of the application. It is contended therein that due to the decisions of the Supreme Court in Jyoti Basu versus Devi Ghoshal, B. Sundararami Reddy versus Election Commission of India, Michael B. Fernandez versus C.K. Jafar Sharif, it is settled position of law that in view of the provisions of Section 82, read with 86(4) of the said Act, the Election Commission of India and its officers cannot be impleaded as respondents to the election petition. Hence, respondents 1, 2, and 3 seek deletion of the names from the election petition. At the outset, this application of respondents 1, 2, and 3 is decided before proceeding with the election petition. It is seen that the respondents 1, 2, and 3 are statutory officers appointed under the said Act, acting under superintendence and control of the Election Commission of India. Thereafter, my lord, 82 is extracted.
Yes.
3.3. From the above, it is seen that Section 82 of the said Act clearly defines the parties who can be joined as respondents to an election petition. Impleadment is restricted only to either the returned candidates, or the contesting candidate, or any other candidate against whom allegations of any corrupt practice are made in the petition. Perusal of the aforementioned 3 decisions of the Supreme Court relied upon by respondents 1, 2, and 3 reveal that Supreme Court has clearly observed that the right to elect or to be elected or a dispute regarding election is neither a fundamental right or a common law right, but confined to the provisions of the said Act and rules made thereunder, namely the statutory provisions. The Supreme Court, while referring to sections 82 and 86(4) of the said Act, has further held that contest of the election petition is designed to be confined to the candidates at the election, and all others stand excluded, and therefore only those may be joined as respondents to the election petition who are covered by the aforesaid provisions, and no other. 3.4. I have perused the 3 decisions. Para 4 in Michael Fernandez confirms the aforementioned settled legal position. The relevant portion of para 4, it is extracted, not necessary. Please take up, my lord. 3.5. Para 3.5.
Yes.
The aforementioned legal position stands undisturbed till date. In view of the above, the application filed by the respondents 1, 2, and 3 deserves to be allowed. There is no serious opposition by the petitioner and contesting respondent 4 appearing in the election petition before me to the application. Hence, application stands allowed in terms of prayer so and so. In view of this order, petitioner shall carry out the necessary amendment by deleting names of respondents 1, 2, and 3 in the election petition within a period of 1 week from today. Re-verification stands dispensed with. My lord, this is a judgment which was delivered on the 2nd of January 2025 of very recent origin. My lord, it is my submission by reason of the precedents which I cited, my application should be allowed. My lord, on merits, I don't want to address.
Thank you. Same. Any add?
I think we added that there is a separate part not devoted in the Constitution of India for the purpose of controlling elections. Apropos section 82, which
আমারই বই নিয়ে আমাকে
But section 82 names not the parties to an election petition. So, but this is a special provision in the statute. Not
the question may crop up as to why the statute does not prohibit any other parties to be included in the proceeding. But not apropos the nature of the adversarial litigation which it entails, but election commission probably has to be kept on the sideline. In the course of an election, it has already applied its mind and taken certain decisions. It's like
Work is over.
yes. Therefore, it should not be a party to a decision already taken. It does not have an interest to defend its own action.
That is the intention.
That's why not this particular sentence in paragraph 9 of that 82 Supreme Court judgment. It has already been placed for your lordship's consideration.
Yes.
Please have a look at the sentence at page 697. If it's the paragraph 9, please see the last 4 lines on that page at 697.
Yes.
It is clear that the contest of the election petition is designed to be confined to the candidates at the election. All others are excluded. The ring is closed to all except the petitioner and the candidates at the election. So that's the idea.
Because this election for the time being by way of notification. Once the election is over, the authorities out of.
Yeah.
Then
But they have already applied their mind. They can't have an interest.
Dispute between the two parties has to go and fight amongst them. Why
So
the
the nomination objection? They have already applied their mind.
Manoj, may I just reply to it, Manoj? Very short. My first is, Manoj, I adopt, Manoj, the submissions of now that Mr. Mojumdar is here, Manoj. I'm really grateful, Manoj, that now it's a very reasonable suggestion, Manoj. And so far as, Manoj, implementing the ECI is concerned, Manoj, now ECI for the first time, Manoj, in these elections, they introduced technology. As in, Manoj, CCTV installation and manning of CCTVs and preservation of records. That was the reason, Manoj, why the ECI was added, Manoj. That, Manoj, relief has been already, Manoj, secured, Manoj, by way of, Manoj, the state filing a report before your lordship, Manoj, that everything has been now preserved. So, Manoj, insofar as ECI is concerned, ECI has also not filed any written statement, Manoj. So, I will not stand in the way, Manoj. The law, Manoj, which was, Manoj, as was being cited by Mr. Banerjee, Manoj, he has referred to a decision of the Honorable High Court at Calcutta also. No, the 2001 judgment, possibly 2001, 2002, yes.
2002.
Yes, Manoj, 2002 Calcutta, Manoj, I will rather, Manoj, garnish that, Manoj, with a judgment of 2002 only, Manoj, of the Honorable Supreme Court of India. It's reported in 2002, volume 1, Supreme Court cases, page 301. Wait, news to. I'm grateful. Mr. Mujumdar is also carrying that. Yeah. So, Manoj, paragraph 8 and 9, basically, this also relied on Jyoti Basu. It states what will be the consequences if I fail to add a necessary party, my application will fail. But if I add, Manoj, parties who are superfluous, their names can be deleted, Manoj. Paragraphs 8 and 9, Manoj. It is therefore clear that on the authorities of this court that those who are mentioned in section 82 of the Act must be made parties to an election petition, and if they are not, the election petition is one which does not comply with the provisions of section 82 and must therefore be dismissed by reasons of section 86(1). It does not, however, follow that if to an election petition parties other than those who are necessary parties under section 82 have been implemented, the election petition
did not comply.
Is the one that does not comply with the provisions of section 82 and must be dismissed. Such a petition can be amended by striking out from the array of parties those additionally implemented. Now, so far as, Manoj, the ECI is concerned, Manoj, I say, Manoj, their application may be allowed. Now, Manoj, coming to, Manoj, Mr. Banerjee's client, Manoj, that is the respondent number 16, the returning officer. Now, Manoj, we have to analyze at what stage, Manoj, these submissions are being made. Manoj, as is known, Manoj, right to contest an election is not a fundamental right, Manoj. It is the right, Manoj, regulated by the statute, that is the Representation of People's Act. It's a special statute. Right to exercise franchise is a fundamental right of every citizen. Otherwise not. So here, where there is a conflict between the statute and the public policy, which one will prevail, Manoj? That is the question, Manoj, that has been troubling me, because I was analyzing, because my lord knows that at different stages of a same proceeding, res judicata applies. So res judicata and estoppel, my lord knows, my lord, are distinctly different, my lord. Res judicata rather No, res judicata rather is, my lord, estoppel by accord.
Correct.
So here, now, my lord, if we take my lord's order dated, the stage is very important, as I am indicating. Order dated 19th of December 2024. Because 19 December, the two respondents appear, 15 and 16.
Yes.
My lord, kindly takes, my lord, page 3.
Yes.
Yes, but kindly takes page 3 of my lord solemn order dated 19th of December 24.
Extension of time to file return statement.
Yes, my lord will kindly take 1, 2, 3, 4, the 5th paragraph. As none appears on behalf of the other respondents, let the suit be proceeded undefended against the other respondents except respondent number 15 and 16. Now, my lord, the para thereafter. Respondent number 16 prays for extension of time to file written statement. Let the written statement be filed within a week after the winter vacation. So I say, my lord, here, my lord, I will be able to rather distinguish the judgments which were cited by Mr. Banerjee about what was the stage. In the cases, my lord, cited by Mr. Banerjee, it was not a case where Mr. Banerjee's client or the returning officer had appeared and said that no, extend the timeline, extend the time period. I intend to file my written statement. Thereafter, the written statement came on record. And then subsequently, my lord, a complete volte-face, a complete turnaround with an application that deletes me from the array of parties.
Yes.
So, my lord, here, I say, my lord, that there is already a decision. This particular, this is a finding, my lord. It is a decision that they have entered appearance
And they file return statement.
and they file written statement. So, this is on the 16th of December, my lord.
Correct.
19th of December, my lord. Now, whether this can be, my lord, this conduct can be termed to be a res judicata applicable vis-a-vis, my lord, the subsequent stage of proceedings, whether at the time of hearing they can take out an application or not.
Yes.
Now, my lord, the Honorable Supreme Court says, my lord, in this was reported in 2005, volume 1, Supreme Court cases, page 787. I have a copy. I go. It 2005 1 Supreme Court cases, page 787. 5-1 SCC, page 787. Para 18 and onwards, my lord, para 18 to para 22. 18 states that it is now well settled that principles of res judicata apply in different stages of the same proceedings. Then para 19, it is well settled that the principles of res judicata can be invoked not only in separate subsequent proceedings, but they also get attracted in the subsequent stage of the same proceedings. Once an order made in the course of proceedings become final, it would be binding at the subsequent stage of that proceeding. Thereafter, para 20, we find in the present case the Tehsildar reopened the very question which finally stood concluded. Namely, the respondent number 1, whether the respondent number 1 was or was not a tenant of the suit land. He further erroneously entered into a new premise of reopening the question of validity of the compromise, which could have been in issue, if at all, in appeal or revision, by holding that compromise was arrived at under pressure and allurement. How can this question be up for determination when this became final under the same statute? Yet again, my lord, thereafter, hope plantation has been cited. And one important consideration of public policy is that decisions pronounced by courts of competent jurisdiction should be final unless they are modified or reversed by appellate authorities. And the other principle is that no one should be made to face same kind of litigation twice over, because such a process would be contrary to considerations of fair play and justice. Now, para 22, law on res judicata and estoppel is well understood in India, and there is ample authoritative pronouncements by various courts on these subjects. As noted above, the plea of res judicata, the technical, is based on public policy in order to put an end to litigation. It is, however, different if an issue which had been decided in an earlier litigation again arises for determination between the same parties in a suit based on a fresh cause of action or where there is continuous cause of action, the parties may not be bound by determination made earlier if in meanwhile law has changed or has been interpreted differently by a higher forum. But that situation does not exist here. Principles of constructive res judicata apply with full force. It is the subsequent stage of the same proceedings, and thereafter, my lord, the decision, my lord, proceeds. Para 30, it states about, my lord, the difference between, my lord, res judicata and estoppel, and res judicata is, my lord, and estoppel by accord. So, my lord, here the question is, my lord, the moot point is whether, my lord, before a court of record, my lord, having plenary powers under Article 215 of the Constitution of India, an affirmed written statement already filed on the basis of the submissions, on the basis of an adjudication that it will not proceed ex parte as against them, my lord. Whether, my lord, this particular application completely pleading otherwise, my lord, can be permitted or not, or if permitted, my lord, the stage at which it can be permitted. Whether, my lord, while allowing the application, my lord, the affirmed written statement already on record, my lord, has to be looked into or not, my lord. So regarding,
then the question would arise, if they filed ignorance of law, whatever it may be, they've taken the time, filed the written statement.
Yes.
But the law find that they are not the necessary party.
But they may not be necessary party, but they have a version, my lord, which they have introduced.
But if the law find and the Supreme Court has held they are not the necessary party, they need not to be a party.
They are surplus, but they are surplusages who have taken a stand, my lord. My lord, may kindly, my lord,
Okay, we will consider that.
while deleting the name, my lord, from the array of parties, my lord may delete it from the stage, my lord, of, my lord, filing of the application, of this particular application, not prior thereto, my lord. The past conduct, my lord, has to be taken on record because they have already filed.
But once it is deleted.
Yes,
yes. It cannot be say he was there because the court has to adjudicate.
Yes.
Court has to adjudicate. The court now first we have to see whether the as per the judgment also, now court has to pass an order to decide whether they has to be deleted or not.
My lord deletes them.
Then deleted, then the judgment will come in.
Yes, my lord deletes them, my lord, taking their stand on record.
Okay.
These are my humble submissions.
No problem. Thank you.
Because it will not, my lord, change the nature and character, my lord, of the petition. So these are my humble submissions, my lord.
Thank you.
I think, my lord, they will not be.
The respondent number 1 never appeared.
No, respondent number 1 never appeared. Thereafter, my lord, his death was
Expired.
also recorded.
Huh?
His death was also recorded, my lord.
Expired.
Yes, his death was also
So what
recorded.
has happened to that the subsequent after the expired no election?
No, my lord,
So if it is expired, how this is maintained?
oh, my lord, it is mentionable, my lord.
How?
What are the rules of the?
Below two dates. May I just indicate 14th of July 2024, these proceedings were instituted. 24th of September 2024, respondent number 1 expired.
No election held.
No, my lord, there is no election held. Yes, my lord, rule 40.
CPC the?
No, my lord, it's the election rules, my lord. I handed over a copy, my lord.
Rule 40?
Yes, the 1967 rules, my lord.
16 section.
It is in the book, no? The separate.
My lord, may kindly take my copy, my lord. Rule 41. ওই অর্ডারটা দেখো যেটা জজ সাহেব রেকর্ড করেছেন। In fact, my lord, that fact of death was also brought on record, my lord. The death of yes. Yes. Kindly take my lord 19 December order.
Yes.
Yes, my lord may now kindly takes my lord's order passed on 19th of December.
Passed away on 24th September 2024.
Yes, yes.
Petition is direct to serve the copy of the affidavit to all the appearing. Petition also filed in showing that the publication of the notice of the present case in English.
And thereafter, my lord, page 3.
But kindly come to the 41.
Please remove. My lord.
If before concludes the trial so
Yes.
the proceedings of the election petition shall be published in the Calcutta Gazette. Where is that?
No. That is, my lord, subject to, my lord.
Yes.
My lord is looking at rule 40.
41.
41, yes. No, if there is no other respondent who is opposing.
Before the conclusion of the trial
Yes.
of an election petition
Yes.
of the sole respondent dies
Yes.
or gives notice that he does not intend to oppose the petition,
Yes.
or if any of the respondent dies, gives such notices as aforesaid.
Yes.
And there is no other respondents who is opposing the
Yes.
petition. The order of the judgment judge.
Yes.
But
Now-
order of the judge.
Yes. Order of
Recording
the-
such facts in the proceedings of the election petition
Yes.
shall be published in the official gazette.
If there is no one contesting or opposing. Now, my lord, kindly takes, my lord, the order dated 19th of December.
19th of December, yes.
Yes. Page 3, my lord.
Yes.
The paragraph that I indicated, my lord, the affidavit, as none appears on behalf of the other respondents, let the suit be proceeded undefended against the other respondents, except respondent numbers 15 and 16. Thereafter, respondent number 16 prays for extension of time to file written statement. Let the written statement be filed within a week after winter vacation. So there was, my lord, it is not a case, my lord, as contemplated under 41, rule 41, that there was no one opposing, because they intended to file the written statement. Now, my lord, thereafter, as the petitioner has circulated the affidavit disclosing the document regarding death of the respondent number 1 in terms of rule 39 of the election petition rules. But kindly takes rule 39. It speaks about an abatement of an election petition on the death of the sole petitioner or of the survivor of the several petitions. Oh, I'm sorry, 39, yes.
39 years
Yes.
after that 41.
Yes. If before the conclusion of the trial of an election petition, the respondent or any of the respondent dies, the fact of such death shall be brought to the notice of the judge by an affidavit to be filed by the petitioner. Copy of the affidavit containing the report of death shall be served on the surviving respondent or respondents, if any, or their advocate. So this has been undertaken, my lord. And it is not a case, my lord, that there was no one who was opposing, my lord, the petition. Because 19th of December, rather a prayer was made on behalf of the respondent number 16, my lord, to file the written statement. And in fact,
Other defendants have become non-suited.
yes,
There were other
others were already non-suited. My lord had already recorded that it will be proceeded undefended against the other respondents, except the respondent numbers 15 and 16. 16 came and 16 said that I will be filing a written statement. And in fact, my lord, thereafter on the next day, my lord, 15th of January, my lord kindly takes the order passed by your lordship on the 15th of January. 15th of January, such and such. Now, my lord, page 2.
Respondent number 16, yes.
Yes. Learned counsel appearing for the respondent number 16 had served the copy of the written statement to the learned counsel appearing for the petitioner and submitted that she will file the same in course of the day in the department. If respondent number 16 files the written statement in the department in the course of the day, the department shall accept the same subject to scrutiny.
But now, Mr. Bhattacharya,
My lord.
if this may be deleted.
No, that is why I, my lord, said, my lord, about Article 250. Now they are trying to resign from the stand taken. So, my lord, may kindly record, my lord, the period from which, my lord, they are residing.
Correct.
So, my lord, this is not a case, my lord, which will attract, my lord, the other consequence of Rule 41. Because Rule 41 at that point of time, upon circulation of the affidavit under Rule 39, it was not a case, my lord, that there was no one who was opposing, my lord. Because this is, my lord, I say, this is a ploy, my lord, to render my petition infructuous, my lord, by the returning, by these respondents, my lord. But I am for the petitioner, my lord, I will be ballistic, my lord. So these are my submissions. My learned friends may not take it personally. It's against their clients, my lord, that I am saying, my lord.
Okay.
These are my humble submissions, my lord.
But I have a short reply.
তুমি কোনটা রিপ্লাই দেবে এবার? এটা তো আমি তোমায় সাপোর্ট করেছি।
No. He wants me to be deleted from today, not prior thereto. My lord, my short reply will be two. Firstly, my lord, Order 1, Rule 10(2). I'll just read the language. The court may, at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just, order that the name of any party improperly joined, whether as plaintiff or defendant, be struck out. 19th of December, I prayed for extension of time to file my written statement. It is not a final order which conclusively determined the rights of the parties. It is not something which says, if you file the written statement, you cannot be deleted under Order 1, Rule 10(2). This is number one. Secondly, if I am deleted from this proceeding, I am deleted from the day this proceeding was instituted on 14th July. Automatically. Secondly, my Lordship is certainly aware of Justice Ajit Kumar Sharka's judgment in Martin Byrne versus Corporation of Calcutta, which is AIR 1966, Supreme Court 529, where, my Lord, in paragraph 14.
Yeah, 1966.
Yes, this is, my Lord, AIR 1966 SC 529. Unfortunately, I don't have a copy.
Yes.
My Lord, in paragraph 14. Paragraph 14 says, of course, the factual narrative is different, but something is very vital. My Lord, may I just read it? We can now deal with the reasoning on which the High Court in the present case justified its order of remand. It realized that by making the order, it was depriving the appellant of one of its chances to object to the valuation, namely the chance under Section 139. But it felt that by upholding that right of the appellant, it would be depriving the corporation as it really rates solely as the time limit prescribed by Section.
Never seen, my lord, while replying, my lord, judgments are cited, my lord.
It thought
Never seen, sir.
that it was faced with two evils, and that it would be choosing the lesser of the two if it allowed the corporation for a chance to collect its rates. With great respect, we find this line of reasoning altogether unsupportable. My Lord, up to this part, it is not relevant. Thereafter, a result flowing from a statutory provision, Section 82, Section 86 in the instant case. A result flowing from a statutory provision is never an evil. A court has no power to ignore that provision to relieve what it considers a distress resulting from its operation. A statute must, of course, be given effect to, whether a court likes the result or not. Only this much.
Thank you.
Lord, we are all grateful for the patient hearing which
Really, really grateful. Okay.
Thank you.
And it's a privilege, my lord, addressing your lordship.
No, I got the chance to hear all of you.
But maybe, my lord, file a short written notes within
Next week. Not
by next Tuesday.
Okay. But what I think,
My lord.
I will pass an order with regard to this application. You have to make the publication, gazette notification.
Very well, my lord.
I will pass that order.
Notification may not be necessary. Why? I'll tell you why in.
Please.
I'm very scared of my learned sister. She gets very angry at times. And she's again angry. So, but here, it is not only restricted to declaration of election of the retained candidates as void, but declaration that I am the winning candidate.
That's why the court is taking view, because now the contesting candidate is not here, and the authorities are taking back, deleting. So it is vacant post. Already it is vacant post. Now you have to be declared. If you have to declare, then the proper procedure is to be followed.
Very good. Very good.
That way I am thinking on that.
The arguments are otherwise over. But what we can do is, my lord, we can file, my lord, our written submissions, my lord, to the main petition, and thereafter, my lord, can direct a publication and.
What I say, within next week, I pass the order with regard to this gazette notification. You complete that and come and file the written notes of argument. I will pass.
Very well, my lord.
That will be better.
Very well. As your lordship please.
Much obliged.
Hearing concluded. CAB.
Grateful, extremely grateful to your lordship.
Thank you. Thank you.
Grateful, your lordship.
Thank you.
Yeah.
Petition or शिक्षण
ঠিক আছে।
क्या हुआ?
Grateful. My lord, I beg to appear on behalf of the defendant number 1. I was cross-examining the plaintiff's witness PW1.
Present.
Lord, best apologies. I submit that our witness is not present today, my lord. He
It was-
suffering. No, my lord.
What cost? How much? Tell me.
My lord, perhaps this is the third or fourth occasion.
Tell me from your mouth. You tell me how much cost you will pay.
My lord, not more than 5,000. my lord.
Even not the 50% of the cost which the court is imposing.
I understand she's talking about James.
Acha, whose witness? Plaintiff's witness?
Yes, my lord.
Present.
No, my lord.
Ah.
He's
When he will present? So can you see in the 19th March also? Further cross-examination deferred, partly cross-examination.
My lord, may kindly keep it after 10 days.
10 days, my diary is not there. Come on, 2nd August.
2nd August.
Total whole day is free.
2nd August is too early, my lord. 9th August.
No. 2nd August is শনিবার দিন court হবে।
Oh, okay.
You will
11th
come.
August, my lord.
You come with your witness. I will record the chief.
My lord, may I only submit, just to requesting my learned junior friend, I requested and called upon the witness to produce certain documents which are and ought to be there with them only.
Issue notice.
During cross-examination, I have called him upon.
Okay, but you give the notice to them, mentioning the question number.
Very.
That will be better. Mentioning the question number, issue the notice to them.
Because I understand if he brings all the documents,
It is bring, it's okay. If not, that's why precautions you will issue the notice to the advocate on record by referring the question. Counsel for the plaintiff submit that though the matter is especially fixed today for examination of the plaintiff, cross-examination of plaintiff witness, but due to some difficulties, the plaintiff witness is not present, and as such, she prays for time. Considering the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear. Give the date. Number September 16 September at 2 p.m.
and my lord, no further accommodation should be removed.
It is made clear that on the date fixed, if the plaintiff failed to bring the witness for cross-examination, the cross-examination of the plaintiff witness will be closed, and the evidence of the plaintiff will not be taken into consideration.
My lord, later that I understood, my lord, the reason of my lord's annoyance with regard to the extension of.
That's why today I am. He's lucky because 243. Otherwise, she could have been taken.
In fact, I was wondering what happened. Then it struck my mind. If we do in all the matters, every alternate matters, that caused annoyance.
Okay.
Good.
Thank you.
My lord, may I mention that?
Yes.
My item numbers 21, 22, and 23. My lord, I am not feeling well for last 2 days.
You persons are not proceeding with the execution case.
I am ready to proceed with the execution case, but my lord, I am waiting here. My turn is not coming. My turn is not coming. What can I do, my lord?
Only your 3 execution cases pending. All execution case has been disposed of by this court.
Only one execution. Other 2 are not my execution.
In this court, all execution has been finished. Only 3 execution of you because you are not doing the matter.
I am one of them. I am one of them. 21 only.
21 only.
Only 21.
Okay, come tomorrow. Next.
Not my tomorrow. Day after tomorrow.
Record on order 21.
21. And the other two are 22 and 23.
Ah.
Actually, it is the order passed by the honorable court to the other side that they must pay the principal amount.
You are appearing for other matter also?
No, I am appearing. Yes, I am there.
21, 22, 21, 19, 20, 21.
21 only. And
Okay.
22 and 23 are the other side.
That is urgent, yes. The item number 21, as per the prayer made by the counsel for the decree holder, case is adjourned. Let the matter appear on 31st July. Yes.
Your Lordship, may I? May I start? Your Lordship, yesterday I tried to establish the fact that the plaintiff should not be entitled to the claim. And I am going towards the last points of my arguments, Your Lordship, wherein the very important item has been raised by the plaintiff that the whole case is revolving around the interpretation of the clauses, Your Lordship. And it was also a contention of the plaintiff that the clauses, namely 4, 5, 6 of the DOS policy, should be declared as void, non-est, and inoperative, Your Lordship. Your Lordship, in my humble submission, this is not just a case of interpretation. And if at all we have to look into the interpretation, it should not be done in isolation, Your Lordship. We must look into the facts of the case while we are trying to interpret the clauses, Your Lordship. My learned senior had been trying to direct the attention of the court towards the interpretation of the exclusion clauses, which are mentioned on page number 80 of the judge's brief, Your Lordship. But what needs to be interpreted, Your Lordship, is the main clause, which is on the page number 77.
Yes.
The second paragraph, Your Lordship, this has been read many a times within the courtroom. I just read from the 8th line, Your Lordship. An accident from there. An accident as herein after defined to the refrigeration machinery described in Schedule 1, resulting in a rise in temperature in the refrigeration chamber, thereby directly causing damage to the goods described in the Schedule 2 by deterioration, putrefaction, or contamination following such accident. So, Your Lordship, here the key word is the accident. There has to be a precursor, which is an accident.
The refrigeration machinery described in the Schedule 1 resulting in a rise in temperature in the refrigeration chamber, thereby directly causing damage to the goods.
Lordship. An accident is the key, but there should be an accident which should give rise to the rise in temperature.
Correct.
That's a very simple interpretation here. Your Lordship kindly comes to page number 68 of the judge's brief. On page number 67, Your Lordship, the general exceptions of the MBD policies are enumerated, and page number 68, clause 4 and 5 are to be looked into.
Yes.
The exceptions include the exception under the MBD policy, under the accident, number 4, Your Lordship, clause number 4.
Yes.
Gradually developing flaws, defects, cracks, or partial fractures in any part, not necessitating immediate stoppage, although at some future time repair or renewal of the parts affected may be necessary. So if there is a gradual wear and tear, that will come under the exception, Your Lordship. Similarly, the next one, clause number 5, Your Lordship. Deterioration of or wearing away or wearing out any part of any machine caused by or naturally resulting from normal use or exposure. Here I pause for a moment, Your Lordship, and I go back to that unthreading incident where in the claim itself, the plaintiff has mentioned that the nut bolt was unthreaded, which proves that it was a normal wear and tear and not an accident, Your Lordship. Your Lordship kindly comes to page number 77 once again. As I said, accident followed by rise in temperature. I take my Lordship to page number 80 of the judge's brief, Your Lordship.
Yes.
These exceptions are under the DOS policies.
Yes.
Especially clause number 4, Roman 4, Your Lordship, under the heading exceptions. 4, 5, and 6 have been challenged by the plaintiff.
Yes.
If I read 1, 2, 3, 4, 5, the sixth line, but I'm reading from the beginning, Your Lordship, clause number 4. Any damage to stocks caused by a rise or fall in temperature due to stoppage of any section or sections of the refrigeration plants for repairs, maintenance, I think it's overheating, or for replacement of parts due to wear and tear. So again, even DOS policy has an exception. If there is a regular wear and tear, then the claim will not be entertained, Your Lordship. Lordship, clause number 6, Roman 6. Any damage if the temperature in the refrigeration chambers does not exceed 40 degree, and it did not go beyond 40 degree as per the fact of the case, Your Lordship.
So what is your case?
There was no accident, which is the precursor to the claim.
That is correct. With regard to the damage, what is your case? How you specify?
So the damage will be covered if there is contamination or putrefaction, which is followed by an accident.
Correct. The damage what the damage was there in the pipe. So how you prove this is not an accident?
As I mentioned, Your Lordship, in the claim itself, the plaintiff has said it was unthreading of the bolt.
Correct.
Unthreading cannot be an accident, Your Lordship. Scientifically, it cannot be.
Where is the evidence you have led? Have you led the expert evidence?
I will support this submission with some more evidence which they have given. The plaintiff has given, Your Lordship, if I may. I'll take you to that place, Your Lordship. Just give me some moment. Under the MBD policy and DOS policy, there are chain of events that has to follow, and the claimant, the plaintiff can claim the insurance claim under the policies. The chain of events are: accident has to happen under the MBD policy, accident to the refrigeration machinery under the DOS policy, followed by rise in temperature, which gives rise to the contamination and deterioration of the stocks. Now, this contract of insurance is covering just one particular peril, that if there is rise in temperature causing contamination, the insurance company will pay. Now, why this is so important? This also goes back to the interpretation thing. Your Lordship, what is the business of the plaintiff? To store potatoes in a cold storage. What is the main element here in this whole process, whole business? Temperature. Temperature is the main element which ensures that potatoes can be kept over for a period of months, years, for a longer period, Your Lordship. So the temperature is the critical element. That's the reason the clause says that if there is damage to the stocks due to rise in temperature, which did not happen. Now, accident, we are contending that there was no accident. Second, exception if there was rise of temperature. There was no rise in temperature.
Yes, may I continue? Yes, yes, continue.
There was no rise in temperature. All these elements, perils which were covered under the MBD policy or the DOS policies are not being operative here. So when we say that we have to interpret the clauses, why are we not looking at the facts given by the plaintiffs, Your Lordship? Your Lordship, my learned friend had raised the philosophy and maxim of contra profrentum. Historically, this rule has been applied whenever there is ambiguity in the clause, there is ambiguity in the contract. Nowhere the plaintiff has come forward and tried to convince the Honorable Court that there was an ambiguity. There was no ambiguity, Your Lordship. The insurance contract covers perils in a certain given criteria, and those criteria are not fulfilled. The ambiguity, neither the plaintiff has shown nor we are able to understand where is the ambiguity. This raises two questions. Is there any ambiguity in the clause of the policy? My humble answer is no. Are there two possibilities of interpretation of the clauses? Again, my humble answer is no. There are no two possibilities. Then how do we invoke the philosophy and maxim of contra profrentum here? I am not able to understand, Your Lordship. Your Lordship, these terms and conditions have been developed, drafted by the Insurance Authority, IRDAI, and they have been there for decades. And till today, no one and nowhere, in no forum, no court, they have been challenged. Suddenly, if it is being challenged, then I don't think this can be just a simple way of interpreting the clause and saying, no, we must follow the maxim of contra profrentum, whenever, even though there are no chances of ambiguity coming into picture. I go back to my college days, Your Lordship, where we were taught contracts law. Between section 24 and 29, which talks about the void agreements, it's very clear. If the elements of ambiguity, if the clause is ambiguous, if the clause is unconscionable or violates the public policy, then they can be considered as void. None of these three elements are being shown here, Your Lordship. The clauses are not against the public policy, they are not unreasonable, and they are not ambiguous. Then on what ground the plaintiff can claim that these clauses should be made inoperative, non-est, and void?
Yes.
Your Lordship, since it is of paramount importance that chain of events, an accident, and rise in temperature has to be established why it should not be allowed, I'm just going back once again to finish my argument, Your Lordship. As I mentioned, on page number 112 of the judge's brief, the claim form submitted by the plaintiff themselves have mentioned that it was unthreaded. The bolt was unthreaded, which indicates even to a normal human being that it was not an accident. It was normal wear and tear, Your Lordship. The preliminary report of the surveyor, as well as the final report of the surveyor, also mentions that there was failure of the flange, the nut and bolt, Your Lordship. Now, can failure be understood as an accident? This is a very open and subjective question, Your Lordship. Even
why failure cannot be an accident?
Cannot be, but failure means something did not work the way it should have worked.
Accidentally, if suppose vehicle is moving on the road and suddenly brake failed, it cannot be an accident.
It causes accident.
Then
brake fail
the
causes
incident
accident.
occurred of the Air India.
So the failure of the brake causes the accident. So that is the reason, but that is not itself an accident. Nut bolt did not work. The pipe, bursted. and ammonia leaked. It did not happen. It just the nut came out because it did not work. So there was a failure. Now I am not an expert, but
That's I'm telling.
yes, Your Lordship.
So this is for it is only for the expert. It can be, this can be accident in the normal course. In the normal course, okay, the gas is flowing through, but due to normal course, the nut bolt has been unthreatened and the gas leak.
Lordship.
Ammonia leak.
Lordship.
Correct. One thing. Or second, whether it intentionally the nut has been unthreaded and kept aside and the incident was occurred. So this two aspect is to be considered by whom? It is to be experts. It is to be expert. Then only you can say yes, it is an accident. Neither the court is expert nor you might be expert.
I'm not, Lordship.
No, you might be expert. But unless the report is not there, so how the court can come to the conclusion what is? Whether you are telling it is accident, it is intentional. They are telling it is accident.
No, they're not saying it is intentional.
No, he's telling that. No,
Yeah,
it
but
is
there is no written statement. There is no allegation of arson.
What the argument since
Yes,
yesterday is making. So if
we have not, Mr. Shaha was there. He perhaps would not have said this also, but I can't resist myself in saying this is an undefended suit. My learned friend is restricted in that way.
Correct.
Which page you are referring to?
Yes. Let he complete. Yes.
Unfortunately, I don't have any ways to bring forward. And Your Lordship, even if you would have defended the exhibits and evidence exhibited by the plaintiff itself speaks about what we are trying to convey, Your Lordship. Your Lordship, as I was mentioning, that both the preliminary report as well as the final report by the surveyor mentions that there was a failure, and they did not, the surveyor did not mention that it was an accident. If I could read one line from page number 120 of the final survey report, Your Lordship.
120?
Yeah, page number 120 of the judge's brief, Your Lord.
Yes.
Fourth paragraph from the bottom, Your Lordship.
Yes.
I beg your pardon, Your Lordship. This is the letter written to the surveyor by the plaintiff, countering the report, preliminary report. They themselves say, Your Lordship, the 1, 2, 3, the third line on the fourth paragraph from the bottom. The stock damage was caused due to impact of ammonia leakage. Page 100, 120, 120.
Paragraph?
It's a letter by the Tirupati Cold Storage.
Correct. 26 July.
Yes, Your Lordship.
Which paragraph?
Fourth from the bottom. Just below, further to complete the formalities, we submit our observation.
Yes, then?
The last sentence, Your Lordship. The stock damage was caused due to impact of ammonia leakage, caused due to failure of spindle and valve. Even they are saying failure.
Correct.
So again, I come back to the same, that how do we understand whether failure can be an accident? So this is open to interpretation, Your Lordship. Your Lordship, the claim under the MBD and DOS policies falls outside the operative or the coverage clauses, and also fall within the exceptional clauses of both MBD and the DOS policy. I will just summarize in 2 minutes, Your Lordship, and then I'll close my arguments. First of all, as I mentioned in the opening statement, that since there is a writ petition pending and basis of the cost of the potato cannot be arrived at, we...
Yes, please continue. Please continue. I'm not interrupting.
So we are not in a position to arrive at the actual claim, if at all there is any. So till that writ petition is disposed, this case should be put at abeyance. Secondly, Your Lordship, I tried to bring forward that there seems...
What is the stage of the writ petition? You have filed the writ petition.
My lord, the writ petition is on absolutely a different.
No, you have
case.
filed.
Yes, yes. My lord, what happened in that writ petition, the contentious issue in the writ petition is that state government has imposed compensation, rate of compensation, which is much higher side, which is on the much higher side. Now, my contract with the insurance company is for a certain rate. So even if I have to pay higher compensation as per government directives, insurance company is not liable to pay that amount. They will pay the contractual amount.
Other than the insurance policy.
Other than the insurance policy. So how it is no way connected.
That
with
is
it. And then there are no record of it here also, and no relief has been sought against the insurance company in that writ petition.
Okay, okay.
But in case, your lordship, if the price of the potato is fixed lower than what the insurance company, it is 13500 something, in that case, what happens?
It cannot happen, my lord.
No, if it is happen also, he is entitled to the claim which is as per the insurance policy is entitled.
My lord. But the claim is based on the price of the potatoes, your lord.
Price of the potato. Price of the potato, now what was, okay.
It was 1,350 rupees per bags, which they are challenging, and the government has said you have to pay more than that. They are trying to bring lesser than that.
No.
Suppose if it is less than 1,350, then what happens?
My lord, in that writ petition, government has imposed a compensation of 2,200 rupees. We are saying that it was insured for 1,300 rupees, so it should be 1,300 rupees. That is our
that is fixed.
That is a rate. That is an insured amount.
Then if it is insured amount, they will get the decree on the same only, if at all. If at all, and the court will declare that it is their risk. You will not be liable. Because the court cannot go beyond the contract. Court cannot go beyond the contract. The court cannot extend the contract. If it is 1,300, it is 1,300 or less. This court cannot go now. You go to the, but the writ court can do that.
Lordship, I also tried to bring to the fore a few elements of mala fide intention, wherein it's not just about the loss suffered due to the contamination of the stock is being claimed for and asked for. They're also asking for extra losses that they have suffered. Unfortunately, no audited financials have been submitted for that year when the incidents happened, followed by Lordship. And also, as I mentioned, no whisper why. Lordship, if the audited financial would have been there, we would have come to know why 7 crores 28 lakhs was taken as a loan. There is no work on the cold storage. There is no requirement for the working capital. Why that money was taken just before the incidents? There is gap of 47 days, 46 days. First time in their business history, they had no coverage. They take the insurance on the within 24 hours. There is an alleged accident. My lord, we are continuing with them for 40 years.
You will get the chance. Yes, let it complete.
This indicates, even when during the cross-examination, when we said that, can you submit, where are the audited financials? There was no answer to that question. If I am saying that I have suffered few losses, what are the supporting
damages to be proved?
What are the supporting documents?
Correct.
Okay. At least the financials would have been there. They are not being supplied, your lordship. So my second point is that I assume there are certain things which is being hidden by the plaintiff, and we must know what are those reasons. As far as interpretation is considered, your lordship, I mentioned that interpretation cannot be done in isolation. It has to be taken into consideration the facts, and then we have to interpret. Interpret cannot happen in air. Just because it is favoring, the interpretation is favoring the plaintiff, we cannot follow that. Your lordship, with all this, I humbly submit that this suit should be rejected summarily, your lordship. And I'm grateful to your lordship for patiently hearing my argument.
Thank you.
My lord, we'll give a very short, very brief reply, not extending more than 10 minutes. And I'll go through, my junior has taken notes of his extensive argument. And my lord, we'd like to give a notes of argument,
yes, both
citing all the judgments. I'll give a copy to my learned friend. while I file it. So, কত দিনের time বল?
Time fix job হবে.
Your lordship anytime fixes this next date.
So you
We'll
will
give a
the
reply on that day. We'll
You will
file
also make submission.
10 minutes, not more than 10 minutes, my lord. তুমিও দেবে তো?
See, this insurance company, this bank, before you may purchase or you go by the saving account, opening saving account, or you purchase the policy, you will feel like, yes, it is very good. After purchasing one or 2 years, they will come and take the collection and they will go. After that, who are you? And if find that you want the benefit of that, then nobody will be there.
This is not covered, that is not covered, car insurance, we keep facing it.
And my lord, just as a passing remark I am making, these clauses are authored by Tariff Advisory Committee. It is a 40-year-old clause. It's continuing, and not in this case, but there has been one case where I argued the matter before my Lord Justice Alok Chakraborty. He has retired now. In that case, one clause, general exclusion number 10 of the standard fire policy, was toned down and said it contra preferentum applies here because it is ambiguous. I have that judgment, my lord, but that is not no way connected. But
No, but he has argued that.
the tariff, yes, my lord. The tariff clauses have been struck down by court. In one case, I was the party.
Counsel for the defendant has concluded his argument. So the counsel for the plaintiff prays for time to give reply. Both the parties are directed to file their written notes of argument. This is the matter. Give कब का रखिएगा? This is the matter. There is no time.
Will not take more than 10 to 15 minutes, my lord. Any day.
When Mr. Shah will be free?
Speak of September.
September.
Will the matter appear?
Any day, my lord. It will not be more than 15 minutes. Maximum.
1 तारीख को 12:30 है क्या? कि 12 है? 12 बजे का कौन सा? 12 बजे का कौन सा कोई दिन है? 12 बजे क्या? 31st. अरे वही तो मतलब 12 बजे से कौन कब है? हम लोग तो 12:30 से रखते हैं ना। 12 लोग से कौन सा मैटर है? 12 नून से 12 नून से कोई भी नहीं है।
Any time is okay. Whatever lordship fixes. Any time is okay.
1st September.
My lord.
At 3:45.
Deeply obliged, my lord.
Great for your lordship. 1st September कहाँ से होगा? 1st September Monday.
And your lordship, we are directed to file the BL.
It come with the written notes of argument on that day.
Deeply obliged.
Yes.
I'm appearing for the plaintiff in this matter.
Your Lordship, I am for the defendant in this case. I do not wish to file rejoinder to their affidavit, Your Lordship. I had filed one GA application, Your Lordship, for getting my cross-examination done in the matter. These are the undefended suits. This is the undefended suit, Your Lordship. But I had filed an application for getting the cross-examination of plaintiff, Your Lordship.
If you see the order dated 11th June, they were given opportunity to file. Then 16th of July, they were given an opportunity to file.
I do not want to file reply.
For filing affidavit in reply, that is not permissible. The second one is for recall of an order by which the suit was made undefended. in which there is a section 5 application. That section 5,
Where
your
is the
lordship,
application for return statement? Which application? By which application they have extension for paid for extension of time to file return statement?
give me the
Okay, which application?
lordship, GA1 is section 5.
GA1 is section 5.
And
Section 5 for what?
your lordship, the suit was made undefended because there is no written statement. So my learned friend has prayed for.
Extension of time to file back.
Your lordship, GA2 is for recall of the order dated 10th of January
Filing
2025.
return, extension of time to file return is which application?
Your lordship, it may there is, your lordship, no such prayer. Only there is a prayer for recall of the order, and your lordship, prayer C in the GA2
Please
only.
allow the application recall the order. When you receive the return writ of summons.
Sir, I had not filed the return statement in time, Your Lordship. 120 days had filed, Your Lordship, has passed away. My only prayer, Your Lordship, today is that let me get a chance to cross-examine the witness.
That's correct. Your application is to dispose of, na? First
Yes, Your Lordship.
to be disposed
29th of April, Your Lordship. 29th of April 24.
2024.
Please, Your Lordship.
And this application was filed
In May, Your Lordship.
May 2025.
5, Your Lordship.
Where do you mention 24th of April 2024?
Your lordship, it's mentioned in your lordship's order. I'll just give the date of it.
No, in their application.
Open it.
Record a note. The defendant, sole defendant.
Sole defendant, your lordship.
Sole defendant, Your Lordship. Sole defendant.
File the present application being GA Com 2 of 2025. Praying for recalling of the order dated 10th January 2025 and to allow the plaintiff to file return statement. Counsel for the plaintiff, counsel for the defendant submit that the defendant has received the writ of summons on
29th of April, 29th April 24.
9th of April 2024, but the defendant could not file the return statement. Accordingly, the defendant has filed the present application praying for extension of time to file return statement. Counsel for the plaintiff has raised objection and submits that the defendant has received the writ of summons on 29th of April 2024. Even after the period of 120 days, the defendant failed to file the return statement. नहीं क्या बोला? क्या बोला? Submits that defendant has received the writ of summons on 29th April 2024. No, citizen 2024, and the defendant has filed the present application only on 19th of May 2025. That is after the period of 1 year. 1 year. He submits that as per the provisions of Order 8, Rule 1 of the Code of Civil Procedure, as amended under the Commercial Court Act 2015, the defendant had to file the return statement within a period of 30 days, and this court has the discretion to accept the return statement within the outer period of 120 days. But the defendant failed to file the return statement within a period of either failed to file the return statement even after the even within the outer period of 120 days, and this application is filed after the period of 1 year. So heard the learned counsel for the respective parties, peruse the materials on record. This court finds that the defendant has received the writ of summons on 29th of April 2024, but the defendant has not filed return statement even within the outer period of 120 days. The defendant has filed this present application on only on 19th May 2025. That is after the period of 1 year after receipt of the writ of summons. Considering the above, this court find that there is no reason to allow the present application by granting leave to the defendant to file written statement. Accordingly, GA Com 2 of 2025 is dismissed. What is the other application?
Your Lordship, in GA2, my prayer is also, Your Lordship, for getting the cross-examine the witness.
So the suit is proceeded undefended against the defendant, as the defendant has not filed written statement, but the defendant is, however, liberty to
Your Lordship may kindly, Your Lordship, GA1 is his Section 5 application.
For what?
With respect to the GA2,
For what?
for recall of the order dated 10th of January. And Your Lordship, with respect to GA3, Your Lordship may see
What
that
is
the
GA3?
GA3 is for cross-examination of the witness. Your Lordship had already closed the cross-examination and examination of the witness on 11th of June.
Where is the GA3? Yes, cross-examination.
Your Lordship, the witness action is already over.
Maybe he will
Your Lordship, I had already requested the clerical commissioner also.
Where is the witness?
Your Lordship, it was examined on commission.
Maybe he will pay the commissioner fee. He will pay the commissioner fee. He has the chance to cross-examination, but he has no chance to file written statement.
But may I just, understandable, if it's undefended, he has a right.
Yes.
But 2-3 dates, Your Lordship would have noticed. Lord, when the commissioner order was being passed, he was present. He was asked to file his vakalatnama. Nothing was done. He thereafter went before the commissioner. Before the commissioner, he was again told that you have to take certain steps. He did nothing. The matter came up. That day, the examination was closed. That day also, he did nothing. Now, my lord, to reopen this, he has a right, but he's allowed the right to lapse.
When the examination chief completed?
11th of June 11th, it was closed.
June
But if you
11th of 2020?
2025.
Okay.
But before that, if your lordship sees,
He filed in 19th May 2025.
but he went before the commissioner. He didn't come here and take any steps. Before that also, twice he has allowed it to. He's actually come. Your lordship has been very.
Your witness is coming from outside.
Sir, I approach the local commissioner also. Sorry.
Outside. From Calcutta. When he will pay the commissioner fee and he will examine, I will fix only one witness.
Only one witness.
I will fix one date. He will pay the commissioner fee. If he will not come on that date, that it will be deemed closed. That will be better. Yes, you tell the when you will be available for cross-examination, I will fix the date on the recording order.
Your Lordship, kindly for a minute, Your Lordship. Kindly give me a minute. Kindly give me a minute, Your Lordship.
Take note if next if the court will fix the date, it will not come and will not examine that date closed.
Only, kindly give 1 minute. Kindly give one minute only. 1 minute.
उनको उसको उन्होंने एग्जांपल ये दिया कि अगर सपोज आई एम प्राइम मिनिस्टर और मेरी बेटे मेरा मेरे प्राइम मिनिस्टर वाली पावर खत्म हो गई है.
So any date in September, Your Lordship, first week of September.
When your commissioner will be available.
Commissioner will be available. 10th of January he was here. He didn't do anything till May. He just could it be sometime in August? He just postpones my hearing of the suit.
Tell me date. I will.
Your lordship will fix the date, no?
3rd of September, Your Lordship. 3rd of September.
August, September. Now, yeah, puja vacation.
August, Mr. Mukherjee is the commissioner. Mr. Mukherjee, he can choose a date in August.
Come on, 26th August.
Sir, 26th August, I have a match. Okay, sir. Okay, sir.
6th August. Or Saturday you're taking. He's taking.
He can take on Saturday if your lordship.
30th of August. Saturday, yes, sir. Saturday.
Any day in August, the Saturday.
23rd August.
23rd August.
Sir, 23rd, I have a matter in Delhi, sir. Currently, 23rd, I have a matter in Delhi, Your Lordship.
It's not a working Saturday.
No, it is working Saturday in Delhi.
Second Saturday, fourth Saturday.
30th
Saturday is working Saturday.
Sir, 30th कर दें सर, ऐसे नहीं.
The plaintiff has, we have been GA3, GACOM 3. The defendant has filed the present application saying
But, sorry, could we ask for it to be on the 9th? Because
9th
he's
of-
taking a month after, taking a date after a month, you know.
9th of August.
9th of August, no?
9th
It's a
of
Saturday.
Saturday, second Saturday.
It's a Raksha Bandhan also, sir. Raksha Bandhan, sir. Raksha Bandhan hai, sir.
Raksha.
9th is Raksha Bandhan.
Raksha Bandhan hai, sir. Sir, 30th August kar de, sir. They have to give me document also. They have to give me affidavit also for that.
The defendant has filed the present application in GACOM 3 of 2025. Saying advising the defendant to cross-examine the plaintiff.
यार तुम रुक जा यार बाहर से कर ले बात
That the witness was examined in commission, but though the counsel for the defendant was present, but has not taken any steps of cross-examining the defendant's plaintiff witness before the commission, and request the rejection of the present. Defendant counsel for the though the defendant has not filed the written statement, and this court has also rejected the application for or extension of time to file written statement, and suit is proceeding independent, but the defendant has a right to cross-examine on the basis of the claim. Thus, for the interest of justice, this court is observing one opportunity should be given to the defendant to cross-examine the plaintiff. We have the defendant and the plaintiff is directed to bring the witness before the commissioner on 30th August 2025, and the defendant is directed to cross-examine the plaintiff witness on before the commission on the same date, and to complete the cross-examination on the same date. It is made clear that if the defendant failed to cross-examine the plaintiff witness on 30th August 2025, it presumes that the cross-examination will be closed. The remuneration of the commissioner shall be paid by the defendant. What is the 15,000 per state? Yes. The remuneration shall be paid by remuneration of the commissioner shall be paid by the defendant. By the defendant. The commissioner is directed to inform the date of hearing of the assistant court is directed to produce the documents before the commissioner on 30th August 2025 as per the convenient time informed by the commissioner, and the commissioner directed to file the report by 9th of September.
The records will also have to be sent.
That's it. 9th of September. GACOM 3 of 2025. As GACOM 3 of 2025. Accordingly, GACOM 1 of 2025 filed by the plaintiff for condonation of judicial for filing of application in GA.
G1 will be filed by the defendant.
One.
Grateful.
Yes. Yes, sir.
Hello.
The next matter.
May I?
Hold on, matter.
Next one.
Just for the time makes it not today. When we have got the supplementary affidavit at 2 p.m., we'll consider that we'll come back tomorrow. I will make it not today. I appear for the plaintiff.
We received the
Today at 2 p.m. Your Lordship.
we served the copy of it.
At 2 p.m.
At 2 o'clock. Lordship keeps it tomorrow.
Which matter?
13, 15.
Not tomorrow. Lord, may I also?
Motion will be taken up, my lord. It will be very difficult otherwise.
New motion will come up. New motion will be
We'll come. We'll come tomorrow, my lord.
My lord,
We'll come tomorrow. My lord, maybe just tender, my lord, this.
Come tomorrow. You
Very,
saw the copy. Come
very well.
tomorrow.
My lord, may I also, my lord, just mention items 84, 85, 86. My lord, it's a suit proceeding ex parte, undefended suit. My client, my lord, was being examined in chief.
My lord, kindly record that the examination chief stands closed in all these 3 suits. My lord, if your lordship recalls, my lord, this is that matter once your lordship got angry with me. My lord,
Yes, all deeds are Xerox copy.
yes, yes. My lord, so my lord, I have, my lord, produced, I have advised the client that we can, my lord, get a decree based on whatever's exhibited so far.
So, but your petition, the witness has to come and it has to be closed.
Very well, my lord, then I will ensure that. Very well.
My lord.
Kindly, my lord, if your lordship can, my lord, fix a day, he can just come for closure and then my lord may fix
No, you
another.
want to, you don't want to, is
Sir, mute.
84, 85?
No, no, 84, 85, 86, my lord.
84, 85, 86. Counsel for the plaintiff submit that the plaintiff witness was examined in part and the chief examination is deferred. But now the plaintiff is not intend to examine the plaintiff witness further and prays for closing of the plaintiff witness.
Yes.
In view of the submission made by the counsel for the plaintiff, the examination of the plaintiff witness is closed. Police, let the matter appear for argument, and list the matter for argument on 11th August.
Any day. I'm grateful.
11th August.
My lord, may I, my lord, mention when he innocuous prayer, my lord, item number 27. My lord, what has happened? Kindly recall, my lord, today the matter was fixed as to and directed me for my application for extension of time to file written statement in the commercial suit. We have prepared it.
Which matter?
Item number OCD 27, my lord.
Ah.
My lord, I was supposed to come with the written statement ready in my hand, my lord, since my application is pending. When I have raised a counterclaim in the suit in my written statement. While paying the court fees, since the respondent's defendant's name has been incorporated as Messrs. M/S, special character is there, the payment is not being accepted online, my lord.
So what you want? 120 days is over.
No, my lord, it will get over on 5th of August. So I just wanted, my lord, this matter may be given some preference tomorrow so that I can, my lord, come before your lordship and
come tomorrow, you issue the notice, come tomorrow, mention the matter. If your written statement is ready, I will pass the appropriate direction.
Yes, my lord. My written statement is ready, but only court fees is not paid, my lord.
Come tomorrow with the written statement and the contract claim. Come tomorrow after notice to the other side. We'll see.
I shall do that. I'm obliged, deeply obliged.